Items for pronouncement of judgment. Item number 28 and 29, WPC 6435 of 2017 and WPC 2516 of 2018.
Both the petitions allowed. Deeply of leverage.
May please, your lordship. I beg to mention this MSc appeal, my lord.
Hmm.
My lord, respondent claimant has died, my lord. May please, can be listed for orders next Monday, my lord.
On Wednesday, 23rd,
My lord. Second appeal also same prayer, my lord. One second.
on 25th. One on 23rd, one on 25th.
Much
Yeah.
obliged, my lord.
May I plead your lordship? Lordship, I beg to mention MSc Appeal 42/2022, which was last listed on 4/11/2022.
In which column?
Lordship.
In which column? Hearing column or order column?
Orders. Order.
Order. When do you want?
22/7. 22/7.
Yeah, please, your lordship, I beg to mention an I, your lordship, arising out of a matrimonial appeal for condemnation of delay, your lordship. Lastly listed matter, it was 11/4/2025, your lordship. So any day, your lordship, next week, your lordship.
Take it at from.
25th,
May it please your lordship,
Yes.
I beg to mention two RSS. The matter may come up in the orders column
When?
next Monday,
on 28th,
28.
May I please your lordship, I beg to list for an urgent listing of matter. Lordship, this is a civil revision petition. Our writ of possession has already been issued by the learned execution court for the tenanted premises, and we may be evicted from the premises. So lordship, kindly list this matter on Friday. Motion for motion,
eviction.
Okay.
highly obliged.
Wait, please, my lord. Item 32 of today's list, my lord. Supplementary motion. My lord, it may kindly be upgraded as the first item. But the eviction drive is going to be carried out in the first half, my lord. After
Item number?
32, supplementary motion, my lord. My lord, I am so sorry for coming this way, but my lord, eviction drives are going to be carried out. So, my lord, that is my problem, my lord. Today. That is our demand. Only if it pleases my lord, then it may be taken up as the first item today.
No, we'll take it up at the, if possible, definitely we'll take it up in the first half. Otherwise, at 2 o'clock. You inform the other side? Yes.
May I please, sir. With concern on other side, lordship, I beg to mention item number 5, lordship. Matter may be adjourned for the lordship.
On the pair being made by Mr.
H. Islam,
Learned Counsel for
on behalf of petitioner, on behalf of R.M. Mazumdar.
R.M. Mazumdar. Learned Counsel for the petitioner. Do you inform the other side?
Yes, lordship.
With consent from the other side, plus for listing the matter. When?
After 2 weeks.
After 2 weeks. Here,
Interim order may be
interim
continued.
order, plus earlier shall continue. Yes.
May I please, your lordship, I beg to mention one RFA for listing, lordship, since long pending, lordship, last listed on 2023.
Hearing.
No, lordship, in orders column.
Okay.
May be taken on
28.
Friday.
28.
Wait, please, your lordship. I pray for listing an RFA for orders this Friday.
When?
This Friday,
On Monday, 21st.
21st. What's up?
May I please, your lordship. Your lordship, I beg to mention item number 22, lordship. And for respondent 3-1, there we have informed the other side, we have taken from the consent. 22. Lordship, we pray for some time, lordship, for today.
We have no objection, lordship. Only the thing is that there is an interim that may be continued.
Interim may be continued, lordship.
As agreed by learned advocates of both the parties, the rest is list the matter. After?
2 weeks, lordship.
After 2 weeks, interim order plus earlier shall come.
Much obliged.
Lord, I pray for listing of this RSF under order of 41, my lord. Urgency, my lord, is that for the learned court is fixed on 21st. And any moment the decree will be executed, my lord. I pray for Friday, my lord.
Okay.
Much obliged.
May I please, the lordship, I beg to mention for listing, lordship. One is RSA matter and another is CRP IO, lordship. Any date, lordship.
Take it at from.
On 38, 30.
May I please, your lordship, so I beg to mention item number 9, your lordship.
Pardon?
9. Kindly pass over the matter for the day, your lordship.
Which one?
9, your lordship.
The pair being made by Miss
M. Medhi, Your Lordship.
Learned counsel for the petitioner. Your name is not there.
No, Your Lordship. I'm on.
You are appearing on behalf of
I, Hussein, Your Lordship.
R. I. Hussein.
Yes, Your Lordship.
Learned conducting counsel for the petitioner. This is always the matter. After
1 Your Lordship. 1
after 1
Oh, plus.
there.
May it please your lordship, I beg to mention listing of a civil revision petition in the 4th week of July, my lord.
What?
Lordship, the matter has become an infructuous matter. It's already been done. There was a stay, and before the stay, the goods were already lifted. The railway allowed to lift the matter. That's why the civil revision petition has become infructuous. That's why listing matter, my lord.
You want to withdraw the same?
My lord, it has been preferred by the Union of India. I am the respondent here.
Acha.
That's why, my lord, I am praying for the mentioning of this matter.
When do you want?
Any date, my lord.
Take it at permanent.
My
30 July.
May I please, your lordship? Lordship, my senior colleague is there, my lord. I want to beg to mention item number 3, my lord.
Item number 3.
It's a matrimonial dispute, my lord, and some mutual discussions are going on, my lord. So lordship may run further 3 weeks time. My lord. In the meantime, we will try our best, my lord.
Okay.
My lord, may make it 2 weeks, my lord. I will take instruction immediately. 2
Okay.
weeks.
Oh,
Okay. As agreed by learned advocates of both the parties, we shall list the matter after 2 weeks.
My lord.
I love that.
Right, Your Lordship. It's a prayer for listing on I 517/25, Lordship.
When? When?
Lordship, any date, Lordship.
On 25th July.
25th. Of Lord.
Items for motion, item number 1.
May please, Your Lordship. Lordship, the petitioner is the wife who is seeking a transfer of the divorce case filed by her husband at Guwahati. She is seeking transfer from Guwahati to Nalbari, Lordship. The grounds, Lordship, her father is old-aging person, and Lordship, the petitioner has already filed 2 numbers of cases, one FC criminal, Lordship, under 125 CRPC, which is pending for the Principal Judge Family Court at Nalbari, and other one, Lordship, one complaint case has been filed by her, which is also pending before the Judicial Magistrate First Class at Nalbari, Lordship. So, in the event of
Whether you have filed additional affidavit?
yes, Lordship. At the time of filing, Lordship, I could not annex the copy of the petition of the filed by the copy of the petition of the said complaint case as well as the FC criminal case before the at Nalbari, Lordship. So this honorable court has directed me to file an additional affidavit to bring on record those petitions. So Lordship, I filed an additional affidavit and which is in the record, Lordship. I bring on record the petition filed by the petitioner. Lordship, in the event of transferring of the case, Lordship, the husband will not be prejudiced because 2 numbers of cases are already pending. At this stage, my limited priority notice may be issued, Lordship.
Wait, what is this? The case is pending?
Sorry, Lordship.
What is this? The case is pending?
The divorce, Lordship.
Yes.
At this stage of SR and WS, Lordship, the petitioner has not got the some notice from this honorable court, but one paper publication has been done. So upon getting the paper publication, the petitioner approached this honorable court by obtaining the certificate copy of the orders.
What paper book?
Lordship, Lordship may peruse page 24 for a moment, Lordship. Paper publication has been done to
Paper publication.
Yes, Lordship.
Page number
20, Lordship.
Page number 20?
Yes, oh, yes, sir. Page number 220, Lordship, of the main petition, Lordship.
Okay, let notice go at this instance.
And Lordship, if possible, further proceeding may be stayed, Lordship, because without the case will be proceeded, Lordship. On last occasion, Lordship.
And how many cases are pending at Nalbari?
Two numbers of cases, Lordship. One will Lordship will find at page 28, copy of the petition.
Okay.
And-
Heard Mr. Krishna Priya, learned counsel for the petitioner. This petition under section 24 of the Code of Civil Procedure is prepared by the petitioner for transferring FC, within bracket civil case number 1130 of 2024 filed by the respondent herein, who is the husband of the petitioner, for dissolution of marriage by a decree of divorce, which is pending before the Court of Learned Principal Judge Family Court number 1, Kamrup and Guwahati, to the Court of Learned Principal Judge Family Court at Nalbari. Mr. Krishnapriya, learned counsel for the petitioner, submits that petitioner is the wife of the wife of the respondent herein. And the respondent here had instituted FC civil case number 1130 of 2024 for dissolution of the marriage, and the petitioner has not received any notice from the court, but she had seen the notice in the newspaper published as per order of the learned Principal Judge Family Court, Kamrup and Guwahati. And on the basis of the said paper publication, she has approached this court for transferring the aforementioned case to the Court of Learned Principal Judge Family Court at Nalbari. This notary further submits that two more proceedings between the same parties are pending in the court at
Nalbari and judicial minister first class at Nalbari and other principal judge family court and principal judge family court Nalbari.
And one case in the Court of Principal Judge Family Court Nalbari. And as such, Mr. Krishnapriya contended to allow this petition and further contended to stay the proceeding of FC civil case number 1130 of 2024 pending before the Court of Learned Principal Judge Family Court number 1, Kamrup, Guwahati, till disposal of the present petition. But having heard the submission of learned counsel for the petitioner, I have therefore gone to the petition. The documents placed on record. Let notice be issued to the respondent, returnable in 4 weeks, that be taken by registered post with AB and also by usual process within a week from today. Further, considering the submission of Mr. Krishnapriya that the petitioner is residing in Nalbari, and 2 more cases are pending before the court at Nalbari. This court is intent to stay further proceeding of FC civil number 1130 of 2024 till returnable that is the 4 weeks.
Item number 2.
Please, Lordship. Civil revision petition, Lordship. Lordship, the respondent is the original plaintiff before the land court bill, Lordship, who has filed the title suit for declaration, confirmation of possession and permanent injunction, Lordship. And Lordship, these 2 petitioners are the principal defendants before the court below, Lordship. And they are agreed with the Lordship closure of Lordship cross-examination of PW1, Lordship. Lordship may kindly come to page number, Lordship, 36. Hide disorder, Lordship, the cross-examination was deemed to be, Lordship, declined by the Lordship defendants, who are the petitioners here, Lordship. May I read, Lordship?
Is the impugn order?
Impugn, Lordship, here, thereafter, Lordship, the defendants have filed another petition praying to allow them to cross-examine.
Tell me which is the impugn order?
Impugn order, Lordship, page number, Lordship, 53. 53. 53, Lordship. They have filed a petition seeking to praying for allowing them to cross-examine PW1 after the Lordship closure of the cross-examination, Lordship. But however, the court below dismissed this petition, Lordship. And thereafter, Lordship, they have filed another review petition seeking review of this order, Lordship. Page 53, Lordship, which has also been dismissed, Lordship. Page 53, Lordship, may kindly see para 3.
Paragraph number 3.
3, page 53. Then Lordship, this petition was dismissed, Lordship. So they were not allowed to cross-examine the PW1, Lordship. Lordship may kindly see the operative part at page number 56, para 9, Lordship.
Whether you have deposited the cost thereafter.
Thereafter, we have deposited. Thereafter, we have deposited, Lordship. And Lordship, against this order, Lordship, we have filed a review petition seeking review of this order. And that petition, Lordship, that order, Lordship, will find at page number, Lordship, 63.
Now, what is this? The case is pending.
It is pending for cross-examination of PW2. It is fixed on, Lordship, day after tomorrow, 18.
Cross-examination of
PW2.
Two.
Lordship may kindly see page 63.
PW1 is completed.
That is deemed to be declined, Lordship. We are not allowed to, Lordship, cross-examine PW1, Lordship. That is because, Lordship, we are here before your Lordship.
No, but you have not assigned any reason.
Lordship,
Going
there
by
is
this paragraph number 9 of the order.
paragraph 9, Lordship, that the non-depositing cost. After this order, we have deposited. After this order, Lordship. And Lordship, there may be some fault on the part of the advocate of the Lordship defendant in conducting
Is
the
it
Lordship.
a ground for allowing its petition?
One opportunity may be granted, Lordship. Otherwise, Lordship, they will suffer prejudice, Lordship, because the PW1 is the plaintiff, Lordship.
Heard Mr. Hassan, learned counsel for the petition. This petition under Article 227 of the Constitution of India. The petitioner has challenged the correctness or otherwise of the order dated 16/8/2024. Caused by the learned civil judge, Junior Division number 2, Tinsukia, entitled sub number 63 of 2022. It is to be noted here that by the order dated so and so, the learned civil judge, Junior Division number 2, Tinsukia, put in bracket trial court hereinafter, has dismissed the heir of the petitioner for allowing them to cross-examine PW1. PW1. When the cost was imposed?
Cost was imposed, Lordship, by order dated 4/4/2024. That Lordship will find at page number 34.
Mr. Gogoi, no, Mr. Hassan, learned counsel for the petitioner, submits that the petitioners are the defendant in the title suit number
63
of 2022. 63 of 2022. And when the case was fixed for cross-examination of PW1, the petitioners took an adjournment on 4/4/2024 and said there was allowed on payment of cost of rupees 1500. And the same was condition precedent for cross-examination of the PW1. PW1. Mr. Hassan further submits that due to why you could not deposit the cost?
That lordship, on next date, the council was not present, lordship. Conducting council.
Mr. Hassan further submits that on the next date, the conducting council of the petitioners was absent. And also on account of poverty, on account of financial constraint, the petitioner could not deposit the cost. Then thereafter, the learned trial court by impugn order dated 16/8/2024 debarred the petitioners from cross-examination of the PW1. Mr. Hassan further submits that thereafter the petitioners have deposited the cost before the learned trial court, and that unless the petitioners are allowed to cross-examine the PW1, they will suffer serious prejudice. Serious prejudice will be caused to the petitioners. And as such, Mr. Hassan contented to grant one opportunity to the petitioners to cross-examine the PW1. Having heard the submission of Mr. Hassan, learned counsel for the petitioner, I have carefully gone to the petition and the place on record, and also in order dated 16/8/2024. It appears that on account of absence of the conducting counsel of the petitioner, and also on account of financial constraint, cost amount could not be deposited in the court, but the same has subsequently deposited by the petitioners before the court. Then also considering the given facts and circumstances, this court is of the view that one opportunity has to be given to the petitioners to cross-examine the PW1. Accordingly, the impugn order dated 16/8/2024 is interfered with. Consequently, the learned trial court is directed to afford an opportunity to the petitioners to cross-examine the PW1 and thereafter to proceed with the case in accordance with law. In terms of this CRP, I will dispose of this motion exercise itself.
Deeply obliged, lordship.
Item number 30. Item number 30.
None appears for the petitioners on call. Is the matter after 1 week.
31.
The lordship will. Actually, file an application under orders 26 rule 10A for sending the admitted signature and also the disputed signature for an expert opinion, my lord. In the background, my lord, I'm just within a second, this is late before this on recording. So there is a society, my lord, SBI Employees Housing Cooperative Society, consisting of the employees of the SBI, my lord. They have purchased the land of 10 acres, and that was, after plotting, that was distributed amongst the employees. Now this plot number 21, my lord, that was leased out to us with the petitioner hearing. In 2008, on 2/6/2008, that plot number 20 was leased out by the plaintiff respondent hearing. By a registered perpetual lease, registered deed. Now this plaintiff has filed a suit in 2018 saying that he was dispossessed on 2/6/2018. He was residing at Guwahati. In his absence, he was dispossessed. The date and month same, but the year is 10 years difference. Then he filed a suit for recovery, declaration and recovery. The plaintiff examined, and cross-examination, he denied his signature of the lease deed. We also adduced evidence. We exhibited that lease deed, along with the transfer of holding in our name, transfer of electricity in our name. This is just a boundary in the eastern boundary of our land. So to carve out this, the confusion whether the lease deed was executed or not, my lord.
You say that conducting counsel for the petitioners submitted before the trial court that Exhibit 1 and Exhibit signatures of the plaintiff in Exhibit 1 and Exhibit D
D is the lease deed. D
are
is the,
similar.
yes, D is the lease deed and Exhibit 1 is the sale deed of the plaintiff. Now, in both the deed, there was a signature which is similar to him. And there was some impression. Now, he denied that he had executed the lease deed. Now, if the lease deed proved by way of his signature, and the matter will be decided, that controversy will be resolved. If I am a leasee in 2008, there could not be any question that I dispossessed the plaintiff in 2018. And lease deed was a registered deed. His photographs are there. Therefore, Lordship will kindly have a look at the impugn order at page 51. The learned court says that is not required for any expert opinion. And no assign, there is no reason assigned. Lordship kindly have a look at page 52, the last page. It also appears from the signature of the plaintiff in Exhibit 1 and Exhibit D that it requires no expert opinion. If the court says by exercising section 73 of the Evidence Act earlier that yes, there's similar signature, then we have no problem. But that was not opined by the court.
No, court finally not adjudicated the matter.
Now that
stage of evidence.
No, my lord, our evidence is completed. Only the official witnesses remain. Now, in two-way, Lordship may kindly exercise. It's my only proposition, my lord. That at this stage, the expert opinion may be asked for, or, my lord, after the conclusion of the evidence, the matter may be afresh decided by the court below. Because that's the only controversial issues to be decided. It will not decided by evidence, oral evidence, my lord. Because he has denied his signature, which is apparently the signature of the plaintiff. That's my problem.
Heard Mr. Dr. Learned Senior Counsel for the petitioner, assisted by Mr.
Esther.
Learned Counsel for the petitioner. In this petition under Article 227 of the Constitution of India, the petitioner has challenged the order dated 28/5/2025 passed by the Learned Civil Judge, Senior Division, Tinsukia, entitled sub number 51 of 2018. It is to be noted here that by the impugn order dated so the Learned Civil Judge, Senior Division, Tinsukia, put in bracket herein after trial court, has dismissed the petition number 4678 of 2024 and petition number 4677 of 2024.
There are two petitions, my lord. One is for under order 26.
Which petition relates to
Yes,
sending
the
of
4678 petition number is relates to for expert opinion, and the petition number 4677 is relates to production of the original sentence. Both the petition rejected.
At the Learned Trial Court had dismissed the petition number 4678 of 2024 and petition number, and also the petition number 4677 of 2024. Mr. Dr. Learned Counsel for the petitioner submits that by petition number 4678 of 2024, the petitioner is right for sending the deed of perpetual lease, being deed number 1008 of 2008, dated 2/6/2008, along with deed of sale, being deed number 676 of 2017. Dated 6/4/2017 for expert opinion as to whether the signature of the plaintiff appearing in the say it are of the person or not? Person. The plaintiff has denied his signature in Exhibit B.
Exhibit D, madam. Exhibit 1 is his the cell deal. So it is an admitted signature. He denies Exhibit D signature, which is a registered instrument.
Mr. Dr. further submits that the petitioner, the plaintiff has denied his signature in Exhibit D. Exhibit D is the deed number
Deed number, my lord, this 1008
1008
of 2008. Yes.
2008. And as such, there is a requirement for sending the same to the FSL for sending the same for the opinion of expert. Opinion of expert, and the same will help in deciding the entire issue. And therefore, Mr. Dotto is completely to allow the petition. And I having heard the submission of Mr. Dotto, I have carefully gone to the petition and the documents plus on record. And also peruse the impugned order dated 28/5/2025. It appears that while rejecting the petition filed by the petitioner, the learned trial court has observed that the signature of the plaintiff in Exhibit 1 and Exhibit D are similar, and that attesting witnesses of the aforesaid dates are yet to be examined, and that the scheduled property of Exhibit D is different from the scheduled property described in the plaint. How do you explain it?
No, that's the boundary, only the difference in the dark number, my lord. There is a difference in the dark number, but the boundary are same. There is a residence there. The holding remains transferred to me, my lord. That all those aspects are not considered by the trial court. Only saying that how the schedule is different. And I am not on that point. I am on the point that whether the signatures are the similar or not. If the lease deed proved, my lord, prima facie, then the entire suit will be decided on that score. There was no other land allotted to him, my lord.
Taking note of the submission of Mr. Dotto, learned counsel for the petitioner, and also considering the facts and circumstances on the record, this court is inclined to dispose of this petition by directing the learned trial court to consider the pair of the petitioner after completion of examination of the attesting witnesses of the aforementioned.
That are remaining witnesses, my lord, DWs, remaining witnesses of the defense. No, attesting witnesses were not called for. This is all official. This is wrongly written by mentioned by the learned court.
Official witness.
Yes. Official
Official witnesses of the defendant.
Defendant.
The petitioner hearing.
Petitioner hearing.
Petitioner's hearing. In terms of this CRP, IO stands disposal.
My application is to be decided afresh, my lord.
At the conclusion of examining, after
Yes,
examination
yes.
of those witnesses.
That would be better, my.
Item 52.
But unless order, this is a respectful submission, my lord. The impugned order has to be interfered, my lord. Otherwise,
Oh, yes.
yes, that one lordship might kindly have it. Because if the impugned order remains there, so that my lord kindly.
Okay, we will incorporate it.
Lord.
32.
May it please, my lord. The civil revision petition, my lord. My lord, we are residents of Jalukbari, Guwahati, my lord. The railway, my lord, railway authorities are stating that the land belongs.
Anybody from railway?
Okay. 32. 33. 34. 35. 36. 37. 38. 39. 40. 41. 42. 43. 44. 45. 46. 47. 48. 49. 50. 51. 52. 53. 54. 55. 56. 57. 58. 59. 60. 61. 62. 63. 64. 65. 66. 67. 68. 69. 70. 71. 72. 73. 74. 75. 76. 77. 78. 79. 80. 81. 82. 83. 84. 85. 86. 87. 88. 89. 90. 91. 92. 93. 94. 95. 96. 97. 98. 99. 100. 101. 102. 103. 104. 105. 106. 107. 108. 109. 110. 111. 112. 113. 114. 115. 116. 117. 118. 119. 120. 121. 122. 123. 124. 125. 126. 127. 128. 129. 130. 131. 132. 133. 134. 135. 136. 137. 138. 139. 140. 141. 142.
No, this issue is covered, my lord. It's similar plot of land, my lord, already eviction has been carried out. And same plan, my lord. It's a railway line, my lord, since 2000. My lord, and this is, first of all, my lord, this is a CRP IO, my lord. It should have been registered as a CRP because against the order under section 5, they have not preferred an appeal. The appeal was dismissed. Against that order, they have come before this court.
Under section 5, we have preferred the appeal before the honorable district judge. It is a part of the records of the petition, my lord.
That is
Under
dismissed.
that is dismissed. Now we have come before the honorable high court
Cannot
because
be IO, my lord, not an
my lord,
interlocutory order.
my lord, since I am the
Matter has
petitioner,
been
may I
closed.
kindly demonstrate my case first, my lord? Since I am the petitioner out here, I'll just demonstrate my case, then my respected senior can start. My lord, here, my lord, the question is regarding the land, my lord. Now the railway claims that it is their land. My lord, our case is that this is dark number 13, old and new 27. The proposed eviction the railway authorities are saying is that we are occupying new dark number 337. My lord, may kindly have page 23 for a moment of the petition, my lord. 23.
My lord, my friend may submit, my lord, before he starts, my lord, will see the orders which are impugned. There are several orders passed by the appellate court which has been challenged. It ought to have been a separate petition. What has been done, my lord, is that all the impugned orders has been challenged in one petition. It cannot be, my lord, will see the prayer portion before my friend starts on merits. Page 19. All the impugned judgments are challenged in one CRP. It cannot be, my lord. And two orders are challenged, impugned judgment and order dated 26/5 and 28/5.
Because
it ought to have been a different CRP, different petition.
No, my lord,
All have different.
All are common judgments, my lord. My lord, may I kindly demonstrate that
It's a
my
fault.
senior
No,
can
it's not a
start?
common judgment. my lord. I'm sorry, my friend is
My lord,
wrong.
matter pertains to the same plot of land, my lord. This has
The petitions are not decided commonly, my lord. These are separate judgments.
My lord, they have
A learned
preferred the
friend is
petition
wrong in saying that it's a common judgment.
My lord,
It has to be challenged separately, first of all. And that has not been done, my lord. That is my basic objection as to the maintainability. Secondly, my lord, it cannot be CRP IO. After these two things are addressed, my lord, then on merits.
my lord, there are judgments of the Honorable Apex Court regarding because this case pertains to public premises, eviction of unauthorized occupants Act 1971. There are 5-bench judgment of the Honorable Apex Court which says that the case has to be done under CRP IO. I have the citation, my lord. I can also provide it before the Honorable Court today.
Okay, produce it. Will say.
My lord, may I kindly start the case first, my lord?
You first saw the judgment of the Supreme Court?
Yes, my lord. Citation I have, my lord. I have not bought a printout because the law is settled. Because it is a 5-bench judge. I have the citation, my lord. I can just. I thought, my lord, the law is settled. My respected seniors know it.
Okay, Mr. Sona, you give the citation to Mr. Gupta.
Yes.
So as to enable him to go through the same.
Yes.
And we'll take it up after some time.
My lord, the people who are going to carry out eviction, they've already reached our site, my lord.
Mr. Gupta.
This order is of 28 May, my lord. They could have come early.
No, my lord.
They are coming in.
There is no limitation per se, my lord.
Till hearing of the petition, you ask them.
My lord, my lord.
They can ask. My lord, I'll just start the case.
33.
You give the judgment to him. Let him go through it.
Wait, please, your lordship. My lordship, may kindly see impugned order page 17, my lord, Annex 2. My lord, in this case, my lord, the petitioner here was the respondent, my lord. The husband filed a case, my lord, under section 24 and 25 of Special Marriage Act for nullity of the marriage on the ground that the certificate was, my lord, forcefully obtained and marriage was, my lord, done, my lord.
No, Mr. Uddin.
Yes, my lord.
Why the marriage certificate is required to be proved?
My lord, their case is that was obtained by fraud.
There is no dispute about the marriage.
No dispute, my lord.
No dispute. Dispute is regarding the age.
Age and fraudulent obtain of marriage, my lord. Lordship may kindly see page 17 is the impugn order, my lord.
How you will show that at the relevant point of time, he was minor?
My lord, that is there, my lord. But their case is that this
No, can you
certificate was,
establish it through the marriage certificate?
yes, my lord.
How?
Because, my lord, we have to call the marriage registrar, my lord. That's why we file a petition.
Definitely, it was shown as a major at that point of time.
So that is why, my lord, it may be the wrong on the part of the my lord, respondent also, my lord. He may commit the fraud, my lord. So that is why, my lord, we file a petition for calling the marriage registrar with documents, my lord. My lord, first of all, my lord, my lord, trial court issue notice, my lord. Thereafter, subsequently, on my lord, 3/4/2025, my lord. That petition was rejected, my lord, and the finding is not, my lord, correct finding, my lord. Lordship may kindly go through it, my lord. I am allowed to read, my lord. Page 17, my lord. And their case is, my lord, on their application, my lord, they have taken the plea that it was obtained by fraud. And our case is that not, it is not obtained by fraud. After my going there, both the, my lord, bride, their witnesses are also there, my lord. And my lord, as per my lord, section 25, Roman 3 of the Special Marriage Act, my lord, that has to be, my lord, proof how it was fraud committed, my lord. Whether it is fraud or not, my lord. I have annexed the certificate also, my lord, page 19. Both the person present there, my lord, three witnesses are, my lord. Then marriage register the marriage, my lord. Now they have taken the plea that, my lord, it was obtained by fraud, my lord. His case is a different one. He signed some documents and it was like there, my lord. So in our evidence stage, my lord, we file a petition. And initially call also, my lord. Thereafter on the midway, my lord, that was rejected, my lord.
No, even if the trial court offered a marriage certificate and registered, how would you establish that at the relevant point of time he was measured?
My lord, that question, that since they have filed, lordship may kindly see their application, they have filed it under section, my lord may kindly see page 38. An application filed under section 24 and 25(3) of the Special Marriage Act 1954, my lord. And under section 25(3) of Special Marriage Act state that, my lord, question of fraud is there, my lord. That part is there, my lord, regarding the age, my lord. Now question is whether it was obtained by fraud or not, my lord. That has to be decided, my lord.
No, by calling the marriage officer and the register, you cannot establish that at the relevant point of time.
My lord, he is the best person. Before him, my lord, it was registered, my lord. In presence of the witness.
He will depose on the basis of the documents produced before him.
Both the person, my lord, husband and wife, went there, my lord. And in presence of the, my lord, register, he has registered the marriage, my lord. Lordship may kindly see the certificate, my lord. Now they are saying that it was obtained by fraud.
In the last paragraph of the order,
Lordship.
the trial court has observed that if it is proved that the marriage officer was convinced on production of some documents before him. And accordingly, their marriage was registered. This evidence cannot be the conclusive evidence regarding the age of the petitioner, which was supplied before the marriage officer at the time of execution of marriage under a Special Marriage Act.
My
And
lord, I am
therefore, calling
not
the
on
marriage
the,
officer
yes.
to ascertain the age of the petitioner will be of no purpose.
My lord, I
That
am,
is the finding. What wrong with this?
I am not on the age, my lord. I am on the, my lord, question of person and fraud part, my lord. Because their case is there, we have obtained this marriage certificate by fraud, applying fraud. And lordship may kindly see that part, my lord, section 25(3), my lord.
No, you show me the petition you have filed before the family court.
Yes, my lord. That petition is that, my lord, page 12.
Page 12.
Yes, my lord.
In which paragraph the plea of fraud was taken?
Plus. My lord, paragraph 4, my lord. Paragraph 3 and 4, my lord. And in their application, my lord, as well as in cross-examination, I annexed, my lord, they have taken the plea that we have obtained that by fraud. Lordship may kindly see page 38.
In this petition, where you have mentioned it that they have taken the plea of fraud.
Yes, my lord.
Where?
I have taken the plea in this question. In the ground also, my lord. Lordship may kindly see the ground, my lord. My lord, see. Page 9.
No, in this petition, where you have mentioned it?
This file before the.
Yes.
Yes, my lord.
Page number 12.
My lord, in this special direct word is not mentioned, but from the case of the, my lord, respondent, my lord, lordship may kindly see, my lord, their application page
No, no.
38. Their application, my lord.
In
it is.
this petition, where you have mentioned it?
My lord, I have not, though I have not mentioned, my lord.
The impugned order was passed on the basis of this application, huh?
Yes, my lord.
Then
That is
it
the,
was not in your petition itself, so then why the court will pass such an order?
my lord, That is directly not there, but my lord, their application as well as their case is that my lord, for it is admitted, my lord. Lordship may kindly see, my lord. I have annexed, my lord, those documents also, my lord. Page 38, para, my lord. My lord, 4, my lord. Para 4, my lord. That is why, my lord, we want to call him, my
No,
lord.
no, if you have not prayed such a relief before the learned trial court, why the court should grant it?
My lord, this is there, my lord, because
Where you
in
told me that
the respondent further back to state authentication of marriage certificate in respect of solemnization of marriage between her and petitioner can be done only by marriage officer or any of his authorized person before the honorable court.
Heard, Mr.
My lord.
Ziuddin, learned counsel for the petitioner. This petition under Article 227 of the Constitution of India. Read with Section 151 of the Code of Civil Procedure. The petitioner has challenged the correctness or otherwise of the order dated 3/4/2025. Hospital learned principal plus family court. Number 1, Kamrup and Guwahati. It is to be noted here that by the Pune order dated so and so, the learned trial court, the learned principal plus family court, Kamrup. Family court number 1, Kamrup and Guwahati, which in bracket hearing after trial court. Though was allowed the application filed by the petitioner for calling no, for summoning the marriage officer Kamrup M in the FC civil case number 534 of 2018. By order dated
Page 17.
when it was first allowed.
My lord, this petition was filed on my lord 27/3/2023, my lord. And
When it was allowed first.
my lord, that was not there, but I have annexed some my lord, order last part. My lordship may kindly see page 8 and 9. On 19/11/2024, my lord,
Why that order is not enclosed with this petition?
my lord, that was not able to obtain, my lord.
Pardon?
That was not able to obtain, my lord.
Why?
Because they only, my lord, supplied from 19/11/2024. And it is mentioned, my lord. In
Where?
19/11/2024, lord. Page 50.
No, that is a subsequent order.
Yes, my lord. Subsequent
The
order.
order by which the court has first allowed your application. You show me that order.
My lord, it was filed on 27/3/2020. I have gone through the e-code,
No, that order you produce
my lord.
before this court.
My lord, today is the case fixed for my lord judgment, my lord. That's why I have urgency, my lord. I yesterday mentioned for lordship, my lord. Subsequent order I have annexed, my lord, on
No,
19/11.
from subsequent order it cannot be asserted.
17/3
You
also
produce
it is
that
called.
order. You file an application there that one revision petition is pending here,
Lordship.
and you produce that order.
My lord, that observation, my
You have also not mentioned in this petition by which order it was allowed first.
lordship. That
Equal line. Heard Mr. Ziuddin, learned counsel for the petitioner. Qualified impugn order dated. Later on, by impugn order dated so.
In ground B, I mentioned my lord about that. In ground B, my lord. Exact date is not I would able to ascertain, my lord.
Held that calling the marriage officer to ascertain the age of the petitioner will be of no purpose. No purpose. But Mr. Uddin, learned counsel for the petitioner is failed to produce the order by which the learned trial court at first allowed the application filed by the petitioner. Accordingly, it is provided that Mr. Uddin, learned counsel for the petitioner, shall produce the order by which the learned trial court has first allowed the petition. Allowed the petition for summoning the marriage officer. Marriage officer. Mr. Uddin order submits that the case is fixed today for judgment, and if the judgment is pronounced, then this petition would become infectious. And considering the aforementioned submission, it is provided that till next date, further proceeding of FC.
Civil case number 534 of
Civil case number 534 of 2018 stands state. So this is the matter on next Monday. Monday you produce.
Most well.
Mission. Item number 4.
May it please your lordship. Lordship, kindly accommodate me in this matter for today only, lordship. Next week, any date, lordship.
Okay. As agreed by learned advocates of both the parties, we say shall raise the matter after 1 week.
My lord, may I pray for a date? They are having a stay over my suit proceeding.
Okay.
24th, lordship.
28/7.
Lordship, interim is there.
Interim order passed earlier Sunday.
Lordship, may I pray item 19 may also be on some other day, lordship, next week. Any day.
Thank you. You inform the other side?
No, lordship, there it's order 41 matter, lordship. Notice not yet issued, lordship.
Okay, on the prayer being made by Ms. Arsoduri, learned counsel for the appellant, raises a list the matter after
Lordship, next week, any date, lordship.
next week.
Oblige.
Item number 6.
May please your lordship. Lordship, the impugn order is at page 87, your lordship. What happened, your lordship? The petitioner is the plaintiff, your lordship. The petitioner filed a suit against the respondents. And they have filed their written statement as well as counter claim, your lordship. And in their written statement, one of my statement that the one special power of attorney, your lordship, executed by the respondents, they have admitted that fact, but they have reversed that that power of attorney was cancelled by later revocation of power of attorney. So I filed a petition under Order 18 Rule 1, your lordship, to lead evidence first by the respondents defendants. That was rejected, your lordship.
So you tell me what wrong with that order?
Lordship, it's because your lordship, my only ground is that lordship may kindly page 26, lordship. Paragraph 4, your lordship. That the father of the plaintiff, late Surendra Singh, expired on Iman, but during his lifetime, the father of the plaintiff, along with the defendants 1, 2, 3, and Propma defendant 4, executed one registered special power of attorney number such and such, dated such and such, before the sub-register Choraido, in favor of the plaintiff, and thereby given the absolute power and authority to construct one commercial building over the front portion of the aforesaid plot of land by taking financial assistance. This portion, your lordship, in page 56, if your lordship kindly go through page 56. Sorry, lordship, page 41, your lordship. Paragraph 16 of the written statement. That though it is admitted that
You are the
the
plaintiff before the trial court.
I am
You
the
are the
plaintiff.
plaintiff.
I am the plaintiff. I just only prayed,
You have
lordship.
to adduce evidence first.
Yes.
Oh,
By the defendant.
no. You have to establish your case first by adducing evidence.
That is there, but my only ground is that lordship, as because
No. Is there any provision in the CPC that
yes,
the
yes,
defendant
yes,
has to adduce
yes, your lordship, yes, order 18.
Order 18, rule 1, 2, and 3, my lord.
Rule 1, 2, and 3, your lordship. Lordship, right to begin, order 18, your lordship. The plaintiff has the right to begin unless the defendant admits the facts alleged, lordship, this part. Unless the defendant admits the facts alleged by the plaintiff and contends that either in point of law or on some additional facts alleged by the defendant, the plaintiff is not entitled to any part of the relief which he seeks, in which case the defendant has the right to begin. And Lordship, now Rule 3, Your Lordship. Evidence where several issues. Where there are several issues, the burden of proving some of which lies on the other party, the party beginning may, at his option, either produce his evidence on those issues or reserve it by way of answer to the evidence produced by the other party. And in the latter case, the party beginning may produce evidence on those issues after the other party has produced all his evidence. And the other party may then reply specifically on the evidence so produced by the party beginning. But the party beginning will then be entitled to reply generally on the whole case. Now, my case is that on the basis of which power of attorney, special power, registered power of attorney, I have constructed, I have carried the construction work on the subject suit length. They have admitted that special power of attorney, but contends that the special power of attorney was revoked by notary. So that I have filed this application. And in this regard, Your Lordship, I would like to refer a judgment of Manipur High Court, Your Lordship. It is paragraph 9, Your Lordship. Before I proceed to deal with these contentions, it is necessary to make some reference to the procedure adopted by the first court in dealing with this case. The appellant brought the suit on the strength of the sale deed Exhibit 1. The written statement of defendant number 1, who alone contested the suit, showed that he did not dispute the fact that there was such a document of sale in the name of the appellant. His contention was that though in form of document was a sale deed, in actual fact, it was intended by the parties to the document only to be a mortgage. He was only repeating the contention advanced by the defendant number 2 before the SDC in mutation proceeding number such and such. On the above pleadings, the learned Munsif ought to have framed the issue in the case with the burden thrown on the first defendant, and he ought to have called upon the defendant to lead evidence in support of his contention that Exhibit 1 was only a mortgage. In this case, Your Lordship, issues were framed. Issues are at page 14, Your Lordship. I have produced. Page 14, 5 issues were framed. And issue number 4 and 5, there is specifically mentioned that the defendant to prove.
The trial court by the impugn order dated 13/12/2023 has assigned the reason for rejecting your petition. So how this impugn order suffers from any illegality or infirmity? So
Lordship, that my this particular ground not considered, so I have approached before this honorable court. That the special power of attorney which was registered, that fact was admitted, fact is admitted by the respondent defendant. And they have also filed their counterclaim in the, so I prayed for leading evidence by the defendant first.
And how does the decision of Manipur High Court will help you?
Because Lordship, here, the a sale deed, the case of the petitioner was, appellant was on the basis of a sale deed.
No, whether sale deed and the power of attorney are same thing.
That is not the same, but the spirit, Lordship.
Spirit. Yes, what is your submission?
My lord, here, my lord, he is projecting a part of the case, my lord, the power of attorney. The thing is that on the basis of that power of attorney, which is now not in effect, my lord, because the person who has executed it has died, my lord. And he is trying to grab the property, my lord, that part of the entire property. And because of that, he has come up with, he has not allowed us to enter into the, my lord, that premises. And because of that, my lord, when we have entered, my lord, this case has arisen. So he has to prove, my lord, whether that person, my lord, where he has constructed that building on the power of the basis of that power of attorney is his absolute property, or it is, my lord, it is admitted that this property is joint property. And all the members, my lord, 5 members are there. They have right title and interest over the said property. My lord, therefore, my lord, the question of partition is there. Whether he has that, my lord, he has come up with that power of attorney and that construction portion where he has constructed. He is alleging that he has constructed. Not only that, my lord, he has not constructed with his own money also, my lord. Our money, we have also invested money in that part. So let him, my lord, prove this case first, my lord. And this section 3 is, my lord, order, my lord, 18, my lord, rule 3. Here, there he will get ample opportunity to rebut my lord, part of evidence again, my lord. That is clear, my lord. Section 3, my lord, what this thing, my lord. Where there are several issues, the burden of proving some of which lies on the other party, the party beginning may, at his option, either produce his evidence on those issues or reserve it by way of answer to the evidence produced by the other party. And in the later case, the party beginning may produce evidence on these issues after the other party has produced all the evidence. If I produce all the evidence later on also, he can produce, he will get the opportunity to face evidence, my lord. So, my lord, where is the illegality and infirmity in this order, my lord? He will get the second opportunity also to give his evidence, my lord, if he give it first time also, my lord. Because he has begun the case, my lord. He has filed the, my lord, my lord, suit, my lord. So he has the second opportunity to also produce his evidence, my lord. Where is the wrong, my lord?
And what is the ratio of this case in
and some of the, my lord, issues are to be proved by him. It is my lord, in the issues, my lord, which is he has written, my lord,
no, I'm asking him what is the ratio of this case?
Lordship,
Number?
Paragraph number 9, your lordship. In that case, lordship, paragraph number 9, may I read again, your lordship? Before I proceed to deal with these contentions, it is necessary to make some reference to the procedure adopted by the first court in dealing with this case. The appellant had brought the suit on the strength of sale deed exhibit 1, your lordship. The written statement of the defendant number 1, who alone contested the suit, showed that he did not dispute the fact that there was such a document of sale in the name of the appellant. His contention was that, though in form the document was a sale deed, in actual fact, it was intended by the parties to the document only to be a mortgage.
And you know the narration of fact, where is the finding of the court?
A finding of the court, your lordship. It is there, your lordship, thereafter, your lordship. he was only repeating the contention advanced by the defendant number 2 before the SDC in mutation proceeding. Iman. On the above pleadings, the learned Munsif ought to have framed the issues in the case with the burden thrown on the first defendant, and he ought to have called upon the defendant to lead evidence in support his contention, Your Lordship.
Which paragraph?
Paragraph 9, later part, Your Lordship. This was all the more necessary because the defendant number 2 had admitted before the SDC that he was paying rent to the appellant after this sale deed exhibit 1, thereby accepting the appellant's case that he had leased out the lands to defendant number 2 after the sale.
So, what are the issues framed in this,
Page 14, Lordship.
page number?
Page number 14. 14, paragraph 5, I have reproduced the issues. 5 issues were framed. Issue number 4 and 5 to be proved by the defendant, Your Lordship. And this particular power of attorney, there is, in respect to the power of attorney, there is a issue number 5. And in respect of loan amount for construction of the building, that part also, that issue also upon the burden upon the defendant, Your Lordship. So my humble submission, Lordship.
Who had executed the power of attorney?
The defendants and their father, plaintiff's father also, who died.
The father of the parties, my lord.
The father of the parties to the present petition, and
It was,
And he expired, my lord.
not only by the father of the petitioners or respondents, by the father of the petitioners and the respondents and the respondents executed along with their father, deceased father. And so after they revoked that registered power of attorney by notary public. They have stated in their written statement, Your Lordship.
And who revoked it?
Their respondents, defendants. Without my Lordship.
Okay, we will see. We
Lord.
pass the order.
Lord.
Mr. Ayerson, learned counsel for the petitioner, and Mr.
Uses again.
Uses Wikia, learned counsel for the respondent. Argument concluded, order is held.
Oblige, Your Lordship.
Number 7.
The decision against an ex parte order passed by the learned district judge in regard to compensation of land. The matter was referred to the learned district judge. The petitioner was also one of the contenders, but he was not heard. So therefore the record was called, and the to show whether the petitioner was served notice or not. That was the purpose of the call. But if I may place the facts, my lord, there was a sale date. That is the record, and the impugn order is at page 41. Starts from page 43.
See. Forward. See. Ready. What does it mean? Page number?
Impugn order is at page, my lord, may I just place one fact before that, my lord? The petitioner purchased the land in the year 2001. That your lordship will get it at page 23.
Page
23.
23 of your petition
My
or
petition.
in a
My
trial court order? Trial court.
Well,
Record of the trial court
no.
or in this petition?
The petitioner. Only for the purpose of giving the background of the case.
Page number?
23. This is a sale date and I'll not, he has purchased 14 letters of land. Description is at page 24. And he was in possession since the purchase of the land, schedule of the land measuring 14 letters, Doug number 111. But it should have been, Doug number should have been 107. Now 2016, my lord, notice for from the circle officer, my lord, page 30. He was also served written notice. I'm just giving the facts. 30. Circle officer has given a notice that is for the purpose of
No, you show me the impugn order.
impugn order is at page 41, my lord.
41.
It starts from page 43. Page 41. While referring the matter, my lord, the petitioner's name was also there. Petitioner was marked with a copy. Page 40 may also be seen.
In the acquisition proceeding, notice was not issued to you.
Yes. No, acquisition proceeding notice was issued to me. All notices are there, but while your lordship will kindly say, first your lordship will kindly say, may I just take 1 minute, man? Page 30, your lordship will kindly say, 30. I'll give 2-3 notices.
Yes.
This is a notice from the circle officer. A copy marked to me also. I have a serial number 4. Amit Bora, you are hereby informed that the date of measurement of the below scheduled land which has been acquired for 4-lane highway is fixed on so and so, hence you and above named Patadas are hereby informed to remain present at the below. So he is there. Now your lordship will again see, my lord, page 232. Same notice was there from the additional deputy commissioner in respect of the same land. And ultimately page 38. From the additional deputy commissioner.
So your name is there.
Yes, and he's saying that there is a complaint from one Gokul Bora, maybe the son of the owner from whom the petitioner purchased the land. And ultimately the matter was referred to page 40. By the additional deputy commissioner. Petitioner name is also marked, my lord. Your lordship will get it at page copy mark, my lord.
Yes.
Gokul Bora, his name is Amrit Chandra Bora. His name is there. I'm referring, and the petitioner's interest, your lordship will kindly see page 48.
Yes,
48.
Yes.
Yes, my lord, based on the last paragraph, based on the field verification conducted in presence of the Patadas, their proportional shares of the land measuring 1 katha 13 tejas of dark number 107 under their possession is shown below. So petitioner is in possession, they will get the money subject to the consents of the co-Patadas. So petitioner's name is at serial number 4, page 49. So in that way of the matter, when the matter went to refer to the land district judge, my lord, he did not hear us. He did not serve any notice to us. So therefore it is protected, my lord, by an interim order, your lordship has protected. Page by an order dated 6/12/24. So the money is pending there, so he has to be heard and the decision has to be taken by the district judge. 6/12/24.
And whether notice was served upon the respondents.
No, not to us.
No. In this petition.
Yes, it was served. It is served. None appear.
None appear.
They have no interest, man. So therefore the matter, this order, impugn order in respect of the petitioner, it should be set aside and he should be heard and appropriate orders should be passed. After hearing him, there is a mistake in the DAG number that he has filed application for rectification. You will submit it before the court. He is in possession of the land since 2001. And that is backed by that circle officer's report, as I have pointed out at page 48.
By which order it was referred to the district judge?
Page 40, my lord.
Page 40.
Copy marked to the petitioner also. Serial number 4, copy marked to Amrit Chandra.
Okay. So, altogether, how many persons are interested?
My lord, all the persons, my lord, lordship will get it at page 40. As many as 16, 17 persons are there.
17%.
Yes.
But from the order dated 25/11/2022, passed by the learned court, indicates
Additional
that
district
the
judge.
notice was issued only to 9 persons.
Yes, my lord.
Why the others were left out then?
I don't, that I have seen. my lord. Others were, maybe they are represented by somebody. But in respect of me, my lord, I was not heard. Only the difference is, my lord, I would have said that I am in possession of the land.
Presented by someone means that has to be reflected in the order.
Not reflected in the. This is a compensation matter. I don't know. Things are different. man. But so far the petitioner is concerned, he has not been heard. No notice has been served on him. Therefore, the order is bad.
Okay, we will set it aside and remand it to the learned trial court.
Well,
Will resume after 5 minutes.
should I be, your lordship will reserve or
No, disposal.
this, your lordship will take up the matter again?
No.
Diploma.
Timing RM 32.
May it please, my lord. My lord, the queries which were raised by my senior friend, my lord, I have brought out a judgment. Can I hand over a copy to the honorable court? My lord, this says that for the Public Premises Act, which is in question, 227 lies, Article 227. 226 does not lie.
227 lines, that was not the question, but whether it will be CRP IO, that was the question. 227, there is no dispute, 227 will lie.
I find
But
it
this
under
has been
227.
registered under CRP IO, my lord, it cannot be.
My lord may hear the petition, then my lord may decide then. I may at least
The
demonstrate
final
my
order.
case.
It will not be IO. The case has been disposed of there. And moreover, my lord, same plot of land, it's entirely a railway land. And the same, my lord, the writ petition number which I have given, 4392 of 2024, my lord, against the similar order by the district judge, my lord, and the appellate order was challenged. If my lord takes page number 2 of that order, this court, by an order dated 29/8/24, had prima facie observed that the judgment and order dated 31/7/24 passed in Miss Appeal number 6 of 24 by the learned additional district judge. This is an appeal, my lord, before the under the Public Premises Act, called for no interference, taking into account findings arrived at based upon proper appreciation of evidence. This courts, upon issuance of the notice, returnable granting opportunity to file an undertaking. Now, my lord, we'll see paragraph 3. In the middle, my lord, the land in question. It starts from that line, my lord. The land in question is described as railway plot number 2, plan number T/01/2023 at North Jalukbari between so and so, my lord, cadastral 330. Exactly same plan, my lord. These petitioners are also in the same area. So they were evicted. Part of the persons, my lord, they were already evicted. And these were remaining persons, my lord. Now today, the eviction process are carried on. And this was sustained, my lord, the order. There was no interference made with the order. And it's already now there cannot be two different treatment, my lord. Otherwise, there will be chaos. One set of people on the same plan already evicted. Now these people are again coming, my lord.
But we have come for the first time, my lord, and there are infirmities in the order of the honorable court
And
below. Against that, I have come because this is a revisional petition. And my lord, the DAG number which my senior friend is referring to, 337, as my senior friend has said. I have records, my lord, which state that I am residing in DAG number 13, my lord. There is a controversy regarding that. There is a case regarding that. My lord, WPC, my lord, will have the last annexure of my petition, 313, my lord. In fact, there is an interim order passed by this honorable court, my lord, 313. Last page of the petition, my lord. Regarding the same dark number. May I kindly read, my lord? It is stated that by an order dated 18/4/99 of the government of Assam and the order dated 10/5/99 of the settlement officer, a total land measuring 64 bighas, 1 kotha, 6 lesa pertaining to KN Patta number 1 was converted to Khera's periodic Patta land and KP Patta number 109 was issued against the said land measuring 64 bighas, 1 kotha, 6 lesa. Subsequently, by an order dated so-and-so of the Deputy Commissioner, Kamrup Metro, land measuring 47 bigha, 16 lesa pertaining to the same Dag number 13 of KP Patta number 109 has been made Sarkari under a new Dag being Dag number 209 Ha. It is stated by the petitioner that the aforesaid conversion of the Patta land to Sarkari was made behind the back of the petitioner without their knowledge under consequential circumstances. The petitioner had submitted a representation which was submitted in the office of the DC Kamrup Metro dated 8/11/10, wherein the petitioner had prayed for a remedial measure against the aforesaid conversion to Sarkari land. It is stated that the said representation is still pending and not given consideration. In the aforesaid facts, it is the case of the petitioner that the railway authorities are attempting to evict the petitioner from the land by claiming that the land in question is a railway land. Now, my lord, this matter is sub judice, my lord. I would like to hand over the last order passed by this honorable court, my lord, in Shahjahan Ali, my lord. May I kindly? It is fixed on 22/7. There is an interim protection. It is fixed for admission hearing, my lord. Would kindly have the last page. That dark number, my lord.
They are different petitioners, my lord.
Petitioners are different, but the question is same, my lord. The dark number 13, my lord. We are also residing in 13. These petitioners in that aforesaid case are also residing in dark number 13.
Those issues already decided by
No,
the
my lord, it is sub judice.
appellate court, my
Sub
lord.
judice, my lord. Plus, my lord, we were not given opportunity by the estate officer. If my lord has page 219 of my petition, my lord, for a moment, it is there in the order passed by the honorable court, honorable district judge also. 219, my lord, has for a moment, my lord, kindly. 218 it starts, my lord, and 219 is the effective portion, my lord. May I read, my lord?
Yes.
Appellant was directed to appear before the respondent number 2 on or before 8/1/24 to show cause as to why he should not be evicted. The appellant accordingly appeared before the respondent number 2 on the appointed date and sought for adjournment to enable him to submit written statement with evidence. However, his prayer was rejected and the respondent number 2 refused to adjourn the case. My lord, there is a provision under the Public Premises Act which says that an opportunity should be given to adduce evidence. I will take my lord to that provision. They have violated the said provision, my lord. My lord may kindly. If my lord kindly has section 4(2)(b)(2).
Section
4. May I read, my lord? Issue of notice to show cause against order of eviction. If the estate officer has information that any person is in unauthorized occupation of any public premises and that he should be evicted, the estate officer shall issue in the manner hereinafter, provided a notice in writing within 7 working days from the receipt of the information. My lord, the relevant proviso is subsection 2, subclause B2, last one, my lord, of the page, to appear before the estate officer on the date specified in the notice, along with the evidence which they intend to produce in support of the cause shown and also for personal hearing if such hearing is desired. Now, my lord, we were not given the opportunity to produce our evidence, my lord, because we sought for adjournment for some time, my lord. On that day, the learned estate officer had refused our plea, my lord. So there are infirmities, my lord. We were not given proper opportunity, my lord. And my lord, it has been settled, my lord, that payment of GMC tax and electricity bill is not a absolute right to the property, but we have been doing it, my lord. I have copies of the same. If it pleases, my lord, I can hand over the copies, my lord.
No, here you see the word it says hearing is desired.
Yes, my lord.
Discretion is led to the state officer, if he desires.
Yes, ma'am. There are provision, my lord, and 8 also, my lord, section 8 of the act also, powers of estate officer, my lord. There also it is said, my lord, to the query raised by my lord. Powers of estate officer. An estate officer shall, for the purpose of holding an inquiry under this act, have the same powers as are vested in a civil court under the CPC when trying a suit in respect of the following matters: summoning and enforcing the attendance of any person and examining him on oath, requiring the discovery and production of documents, any other matter which may be prescribed. My lord, that point B, my lord. Requiring the discovery and production of documents. My lord, documents we wanted to give, we had sought for some time, my lord. But it was not given, proper opportunity was not given, my lord. It is against natural justice, my lord. Again, flagrant violation of our natural justice, my lord, at the end of the day. That is why, my lord, and moreover, the connected case is pending, my lord. This dark number is in controversy. That is why, my lord, some interim protection may be given, my lord.
The entire issue was discussed by the appellate court. My lord will take page 53,
53
paragraph 10.
53 of
53 of this petition, my lord. In fact, my lord, all the orders the petitioner has challenged in a single petition, it cannot be. There has to be different CRPs. My lord will take page 53, paragraph 10. The respondent number 2 has appeared before the estate officer. If I may read, my lord, the paragraph. Page 53, paragraph 10, my lord. It is stated that from the records, it is crystal clear that the aforesaid premises belonging to the railway authority is covered by DAG number 337 of village Sadilapur of Moza Jalukbari, and as such, the aforesaid premises being under occupation of the appellant is not a private land as claimed. Hence, notice was issued to the respondent number 2 on 19/12/23 to the appellant to appear before the respondent number 2 on 8/1/24, and accordingly, the appellant appeared before the respondent number 2 and participated in the hearing by filing written statement on documents. My learned friend, on the contrary, is saying he has not been given any opportunity of hearing. Hence, the plea taken by the appellant that he sought for an adjournment which was rejected is out and out false. Thereafter, my lord, it is also stated that the appellant could not produce any document to show that he was lawfully possessing the aforesaid premises, and as such, the respondent number 2 rightly held that the appellant as an unauthorized occupant of the premises in terms of section 5 of the 1971 Act. In view of the aforesaid, it is prayed that the appeal may be dismissed in support of the evidence. And all the plea has been considered by the appellate court. It's a railway land, my lord, and this judgment which I have given, my lord, it is already declared to be railway land. Part of the persons from that plot has already been evicted. Now, how can, my lord, the petitioner, there will be differential treatment, my lord. Admittedly, and all the issues has been discussed by the appellate court, and after discussing, only this finding has been allowed. Now, my lord, this court cannot be made a second appellate court. My lord will just, the judgment which my learned friend has given, if my lord will take paragraph 14 of their judgment. The power under 227, my lord, again, there cannot be reappreciation of the evidence at this stage. And this plea ought to have been taken. The petitioner, my lord, they have not annexed their defense. My lord will see this petition. There is what defense they have taken. They are saying for the first time all this plea here before the court under 227. They have not annexed their WS before filed before the appellate court, stating that these pleas were taken and those were not considered. Those documents have not been annexed by the petitioner. And my lord, paragraph 14, if I may take, my lord.
yes.
In view of the such binding decision, the inescapable conclusion presenting itself is that appellate order under challenge before the High Court was rendered by a civil court, and it is tried that the orders passed by a civil court cannot be challenged in a writ petition under 226 of the Constitution of India.
227.
This point of law has been decisively reiterated in the three-judge decision in Radhesham versus Shabinath. This court, while holding that an order of the civil court could only be challenged under Article 227 of the Constitution and not under 226 thereof, ruled that all the courts in the jurisdiction of a high court are subordinate to it and subject to its control and supervision under Article 227. Writ jurisdiction constitutionally conferred on all the high courts. Broad principles of writ jurisdiction followed in England are applicable to India, and a writ of certiorari lies patently erroneous and without jurisdiction orders of tribunals or authorities or courts other than judicial courts. There are no precedents in India for the high courts to issue writs to the subordinate courts. Control of working of the subordinate courts in dealing with their judicial orders is exercised by way of appellate or revisional power under powers or power of superintendence Article 226. Orders of a civil court stand on a different footing from the orders of authorities or tribunals or courts other than judicial civil courts. While appellate court or revisional jurisdiction is regulated by the statutes, the power of superintendence under Article 227 is constitutional. Thereafter, my lord, paragraph 16, my lord. The test for exercise of such power was laid down, while I am reading paragraph 16 from the last paragraph onwards, my lord. The test for exercise of such power was laid down in a 5-judge constitution bench decision of his court in Rajendra Diwan versus Pradeep Kumar Ranibala. The power of superintendence conferred by Article 227 is, however, supervisory and not appellate. It is settled that this power of judicial superintendence must be exercised sparingly to keep subordinate courts and tribunals within the limits of their authority. When a tribunal has acted within its jurisdiction, the court does not interfere in exercise of its extraordinary jurisdiction unless there is grave miscarriage of justice or flagrant violation of law. Jurisdiction under Article 227 cannot be exercised in cloak of an appeal in disguise. In exercise of its extraordinary power of superintendence and judicial review under Article 226 and 227 of the Constitution of India, the High Court restricts interference to cases of patent error of law, which goes to the root of the decision, perversity, arbitrariness, unreasonableness, violation of principles of natural justice, lack of jurisdiction, and usurpation of powers. The High Court does not reassess or reanalyze the evidence and all materials on record. The writ jurisdiction of the High Court cannot be converted into alternative appellate forum just because there is no other provision for appeal in the eye of law.
For revision only I filed. This is not an appellate case, my lord. For
It is
revision,
reappreciating whatever plea my learned friend is taking. He has not shown from the records that he has taken those pleas before the court below, and that was not addressed by the appellate court.
that I may.
Those copies have not been annexed.
You have filed your objection before the district judge?
My lord, appeal we had filed before the district judge. Then WS was filed by the railway authorities. My lord, I have applied for the copies since eviction drive is today, my lord. My humble prayer is that
their petition
for the
is not on
time being,
record,
my lord, we might be protected. I'll bring it on record. I'll file an affidavit to that effect. I'll
How
bring
can
those on record.
their petition, my lord, by which the order of eviction in the Section 5 was challenged, that ought to have been put on record by the petitioner, stating that these pleas were taken and these pleas were not considered by the appellate court. And apparently, similar case, my lord, already there is an order of eviction.
My lord,
There cannot
kindly
be
have
two
page
different
24 for a moment, my lord, of my petition. 24 for a moment, my lord. This is one crucial letter, my lord. This is from the circle officer, my lord. Guwahati Revenue Circle to the Senior Divisional Engineer, NF Railway, my lord. May I read, my lord? Page 24, Annexure 2, my lord. Kindly. May I read?
Mr. Gupta, okay. Is there any document to show that that tag number 337 belongs to the railway?
Yes, my lord, there is a specific finding.
Paragraph?
Paragraph 9, page 57 of the order of the learned district judge, my lord. The circle officer, Guwahati Revenue Circle wide letter dated 10/5/23 informed the railway authorities regarding demarcation cum survey of the land measuring 756.10 R of village Sadilapur under Jalukbari Mauza as recorded in the remark column of the Chitta of the Government Railway Department. Subsequently, memorandum of understanding for exchange of land between Northeast Railway and Assam State.
57.
Yes.
Page?
52, that is 52, my lord. Wrongly, it is 52.
Why?
52, 52. 52. Paragraph 9.
Yes.
There, my lord, the circle officer, Guwahati Revenue Circle wide letter dated 10/5/23 informed the railway authorities regarding demarcation cum survey of land measuring 756.10 R of village Sadilapur under Jalukbari Mauza as recorded in the remark column of the Chitta of the Government Railway Department. Subsequently, memorandum of understanding for exchange of land between Northeast Railway and Assam State Corporation was executed on 14/6/23 on equitable value of land basis. The scheduled premises of railway land measured 20 bighas, 2 kattas, 1 licha is covered by dag number 576 old, 337 new of village Sadilapur. The circle officer, Guwahati Revenue Circle wide letter dated 31/23 informed the Assistant Director of Land Records and Survey regarding joint verification of physical demarcation of the railway land on 7/11/23. Accordingly, the joint demarcation was held on that day in the presence of the officials of the Railway, ASTC, Revenue Department, and Assam Survey of Land, and the respondents' wide letter dated 15/11/23 addressed to the ASTC communicated about handing over the land of ASTC at Paltan Bazaar to the railway authorities. On 18/11/23, the ASTC wrote to the railway authorities that although the land was demarcated, it was reported that the land measuring 20 bighas, 2 kattas, 1 lichas belonging to the railway authorities was under encroachment of around 30 to 35%, which required to be evicted. By letter dated 2/5/24, the ASTC requested the railway authority to deliver and hand over the peaceful possession of the said land without any encumbrance, so that necessary correction of land records can be made in the name of ASTC.
My lord, pursuant to
Then in paragraph 10, my lord, it is stated from the records. It is crystal clear that the aforesaid premises belonging to the railway authorities is covered by dag number 337 of village Sadilapur of Mauza Jalukbari. And as such, the aforesaid premises being under the occupation of the appellant is not a private land as claimed. Hence, notice was issued to the respondent number 2 on 19/2/23 to the appellant to appear before the respondent number 2 on 8/1/24, and accordingly the appellant appeared before the respondent number 2 and participated in the hearing by filing written statement and documents. Hence, the plea taken by the appellant that he sought for an adjournment, which was rejected, is out and false.
Different petitioner, my lord. I was reading that.
Same petition.
Petitioner
One,
was-
I am reading on
petitioner
their
six-
petition only, my lord.
Petitioner number 6 didn't get an opportunity. This is another petitioner. There are 8
My
petitioners.
lord, petition number, that same question, same thing what I am telling. How can all the petitions can be clubbed together? There are different orders passed by the, against different evictions under section 5.
Otherwise also.
Cannot
that
be
num-
clubbed together,
that
my
number
lord.
has not been appreciated, my lord. I'm
He is
saying,
making
my lord, this is
different
document
pleas.
13 where we are residing, my lord.
Each order of the appellate authority, my lord, under the Unlawful Eviction Act 1971 has to be, my lord, adjudicated separately. It cannot be clubbed together.
Grievances are common. That is why we have approached this court together, my lord.
Some places they are saying, my lord, they have not been given opportunity. Some
Only
places they are saying opportunity is given. Each case has to be dealt with separately, my lord.
When evictions
And
happen,
it is not clear, my lord. It's very clear. All the issues has been
There are
discussed
some urgencies.
by the appellate.
No, that's all right, but what document you?
My lord would
able
kindly have-
So that,
Yes,
the
yes.
land in which
Page
you are.
24, my lord would 24, my lord.
Page
Annexure
number?
2, 24, Annexure 2, my lord would kindly have. This is the letter from the Guwahati Circle Officer, my lord, Revenue Circle Officer, letter dated 10/5/23 to the Senior Divisional Engineer, NF Railway, my lord. May I kindly read, my lord? if my lord has the page, 24, my lord, annexure 50. Yes, my lord, I'll read. With reference to the subject cited above, and in response to your letter under reference, I have the honor to inform you that land from Haj Bhavan to Brahmaputra Bridge, covered by DAG number 178, 325, 326, 327, 328, 329, 330, 331, 332, and 333 of village North Jalukbari under Jalukbari Moza was verified by the concerned LM Latmandal, and the details are as under. As per land record, land measuring 46.82 ARE covered by DAG number 13 old / 27 new is recorded in the remarks column of Chitta as Railway Department. Land measuring 38.23 ARE covered by DAG number 12 old 12 new is recorded in the remarks column of Chitta as Government Brahmaputra Bridge. Land measuring 15 ARE covered by DAG number 11 old and 13 new is recorded in the remarks column of Chitta as Village Road. Further, land measuring 112.60 ARE of village North Jalukbari under Jalukbari Moja covered by DAG number 245 old 14 new is recorded in the remarks column of Chitta as Government Brahmaputra Bridge, and land measuring 104.10 ARE of village North Jalukbari under Jalukbari Moja covered by DAG number 13/269 old 15 new is recorded in the remarks column of Chitta as Railway Department. Again, land measuring 756.10 ARE of village Hodilapur under Jalukbari Moja is recorded in the remarks column of Chitta as Government Railway Department. Further, it is to be mentioned here that a civil suit number 511 of 2018 is pending in respect of land covered by DAG number 12N, 13N, 14N of village North Jalukbari under Jalukbari Moja before the Honorable Civil Judge number 3, and land covered by DAG number 13 old of village North Jalukbari under Jalukbari Moja is under sub judice before the Honorable High Court. Further, there is a mismatch of the DAG number mentioned in the letter under reference with the land records, and a detailed list of the lands in question is enclosed herewith as Annexure 1 may kindly be perused. Next page is the Annexure 1, right? That is Annexure 3 of this petition. Here, my lord, the first column, my lord, would kindly have Jalukbari, village North Jalukbari, DAG number old 13, new 27. That is the question, my lord. My lord, it is written, but in the
remark column, it is shown as a railway
department. But in the previous communication, my lord, it is stated that the matter is sub judice. That is the discrepancy I am saying. Let them clear the air, my lord. It is confusing. We are also confused. So, my lord, they may clear the air. Reply may be given by them, my lord.
No, my lord, will take
Yes, madam, please come this side.
One.
In page 25, Annexure 3, Lordship, name of the Patladar. Here is in all the cases, it is a government land, government. And remarks, it is Railway Department, Brahmaputra Bridge, Village Road, Brahmaputra Bridge. All are in government land, Lordship.
Then their letter 10/5/23. Their letter only. We are
Apart from page number 24, do you have any other document?
No, my lord. Apart from that, I have got Khazana receipts and everything which we have been paying since
No,
lot of
Khazana
years.
receipt will not do.
My lord, electricity bill, Khazana receipt.
My lord, will take paragraph 28 also. Page, all the issues has been discussed by the appellate court. Page 68. Circle officer was called, my lord, he was examined.
Page number 68.
Page 68, paragraph 28, my lord.
Yes.
The respondent railway has placed on record a judgment and order passed by the court of the learned additional district judge number 1 in Miss Appeal 624 dated 31/7/24, which involves a part of the same land in question in the present case, but which was occupied by a different person in the aforesaid case. It would be instructive to reproduce the following paragraphs from the said judgment, which is relevant under section 42 of the Evidence Act, as it involves a matter of public nature, whether the land is a public premises or not. So far as clarification of the fact as to whether the land in question is covered by DAG number 13 old slash 337 new of KP Patta number 1, or it is covered by DAG number 576 old 337 new. The concerned circle officer, that is the circle officer of the Guwahati Revenue Circle, has been summoned, but the circle officer is on leave, and as such the concerned Latmandal appeared along with the relevant revenue record, who is examined as CW1. CW1 has stated that there is no land physically exists comprised in KP Patta number 1 in DAG number 13 in village Sadilapur under Jalikbari Mauza. He has further stated that there is no land comprised in DAG number 13 old 337 new in village Sadilapur under Jalikbari Mauza, but there is a land in village Sadilapur under Jalikbari Mauza comprised in DAG number 576 old and 337 new. And according to the Chitta mutation, the said land is recorded in the name of railway. Exhibit X is the copy of the Chitta mutation in respect of the land of village Sadilapur under Jalikbari Mauza, comprising DAG number 576 old 337 new. The DAG number 13 shown in the Zamabandi of village Sadilapur under Jalikbari Mauza lot number 2 of Patta number 0 was covered by old DAG 308, and the said land of DAG number 13 is the river bank, and there is no encroacher over the said land according to the Chitta. My learned friend is claiming over DAG number 13. There is no land there. Exhibit Y is the Chitta pertaining to the land covered by DAG number 13.
Okay. Yes, Mr. Sorma, where
There
is
is a
your
sufficient evidence, my lord.
That is the recording of the Honorable District Judge.
That is the finding of the court.
Finding of the court, man.
Then
But this letter, my lord.
except this page number 24,
Yes, my lord.
you don't have any other document to show that there exists any land
My lord,
covering DAG number 13.
my lord, this is the only, otherwise, my lord, we have some,
Where is the prima facie case to grant stay? Anyway, let notice go at this step.
till then, some protection.
No, sorry. No prima facie case.
There is no prima facie.
Heard Mr. Sarma, learned counsel for the petitioner, Mr. Gupta for respondent number.
My lord. 1 and 2.
Respondent number 1 and 2, Madam Burman for respondent number. Respondent number 4. Mr. Hendrik for respondent number. Respondent number 3, and Mr. Gogoi. Same. Okay. Okay. In this petition under Article 227 of the Constitution of India, the petitioner has challenged the judgment an order dated 24/1/2024 passed by the learned state officer NFLA Maligaon in connection with eviction case number EO/MLG/27/2023. And also the judgment dated 28/5/2025 and 26/5/2025 passed by the learned district and sessions district judge in case appeal number 14 of 2024 and Miss appeal number 20 of 2024. Where is the petition and the documents placed on the record? Let notice be issued to the respondent, returnable in 2 weeks, step be taken by registered post. No, however, no formal notice is required to be issued since all the respondents are represented by their engaged counsel. However, extra requisite copy of the petition be furnished to them. It appears that Mr. Sarma, learned counsel for the petitioner, has not enclosed the copy of the memo of appeal preferred before the Court of Learned District Judge, being Miss Appeal number 14 of 2024 and what is the other number?
My lord, missed appeal number 20 of 2024, 21 of 2024, 22 of 2024, 16 of 2024.
And accordingly, it is provided that the petitioner shall bring on record the aforementioned memo of appeal by filing an additional affidavit. Though Mr. Sarma, learned counsel for the petitioner, has contended to grant interim stay till next date. Yet, having heard the submission of learned counsel for both the parties and also considering the facts and circumstances on the record, especially the impugned judgment and order so passed by the learned district judge, Kamrup, Guwahati. This court is unable to find out any priority case for granting any stay of the impugned judgment and order, and therefore the prayer for interim relief stands rejected.
May it
List
please,
after 2 weeks.
may it please, my last prayer, my lord. If it pleases, my lord. My lord, we are at the end of the day human beings, my lord. Some time may be given to us to, we'll take out our materials from there, my lord. If the eviction drive is going to be carried out, today it is going to be carried out.
They have come late, my lord.
Sometime,
May order,
just sometime.
order passed in May.
At least our valuables, my lord.
Sorry.
I'm deeply obliged, my lord.
Item 8.
May please, my lord, I am on behalf of petitioner, my lord. I have filed this case, my lord, regarding the order dated 1/4/25, my lord, passed by the municipal. That they have filed a amendment and counterclaim, my lord. I have filed a suit, my lord, only for 1/10 lesser, my lord, covered by Doug number so and so, pata number so and so, Rampur. There the defendant is the tenant of the land, my lord. His mother was expired on 1981, my lord. And as per Hindu Succession Act, they are not the right of the paternal property, my lord. Subsequently, they have filed a written statement and filed counterclaim. And when the case is fixed for cross-examination, my lord, plaintiff already filed the evidence in affidavit, my lord. And that stage, my lord, they have filed a petition for amendment or counterclaim, my lord. And this amendment is that they have added another two plot, my lord, the schedule Y, which is that number is difference, pata number is difference, my lord. If they are that is not the limitation for amendment of counterclaim, my lord. That recently on the, they have stated that recently, that the counterclaim state that recently on the basis of an application submitted by the plaintiff before the circle, Polasbari Revenue Circle for demarcation of their bosti, and the counterclaim has come to know that decided the land covered by Doug number so and so, pata number so and so, schedule 1 Y, that is page 9, my lord, paragraph, first paragraph, my lord, same as covered by Doug number so and so, pata number Rampur Moja under Polasbari Revenue Circle in the district of which has been described in schedule Y1 and Y2, my lord. But the plaintiff, I have denied the same, my lord, because I have filed a suit only for 1/10 lesser, out of 3/12 lesser, my lord. And subsequent land, my lord, they have added in your first previous counterclaim, my lord. And thereafter, at the time of the stage of cross-examination, they have filed this petition, my lord, amendment and counterclaim. It is the statutory limitation is not covered, my lord. Counterclaim only be based on the cause of action is obtained, my lord. If they have added the two schedule, they have filed a separate suit, my lord. Fresh separate suit, my lord. In the same schedule, for fees effective, my lord.
No, is there any bar in filing counterclaim?
Yes, my lord.
Huh?
Then, my lord, annexer. Copy of title said annexer 1, my lord. Page 30. Page 30, my lord, annexer 1. That is the plan, my lord. I have filed a schedule page 16, my lord. Page 60. That is mentioned in schedule.
Page number?
Page number 16, my lord. Mention the schedule, my lord. 1/10 lesser covered by Diac number 1291, KP Patta number 396, Revenue Village 3, 3 number Rampur, Moza Rampur, district Kamrup, Assam. North National Highway, south land of Mahesh Mohanto, east of Ratan Mohanto, west of land of Thiren Bhia. This is the, there's the tenant, my lord. Previously their father is approached us for rented house. He is the teacher of the Rampur High Secondary School. But subsequently he, when he retired, he left the house. And on 2018, the present defendant approached us for rented house, my lord. And I have provided rented house. Thereafter, my lord, I have stated him to vacate the house, but they are not intentionally, they have grabbed my house, my lord. And thereafter, I have filed this suit, my lord. And they have claimed they are the maternal property, but their mother was expired, my lord, 1968. So as per Hindu Succession Act, my lord, a married daughter is claimed if their father was expired after 2005, my lord. Hindu Succession Act, my lord, amended 2005, my lord. So their claim is not maintainable in this present case, my lord.
Yes, Mr. Bhuya, what is your case?
Lordship. The one Kamini Mohanto, the predecessor of the petitioner, plaintiff, and the mother of the present respondent here, they were the legal heirs of Kamini.
There?
Legal heirs, son and daughters.
That's it.
Besides my mother, there is other sisters also.
Hmm.
So that Kamini Mohanto gave a share of land.
Let's use the microphone.
Lordship. That Kamini Mohanto,
Hmm.
the father of the petitioners, gave a plot of land 1 kata 10 lakhs to his daughter, that is my mother. And my father, he was a teacher. And at that time, he constructed in the where he built some type houses and structures. So he died. And thereafter, we reside there. We have a other daughter, except me, there is other daughters and sisters and brothers and sisters of my the respondents. So suddenly they filed this suit, claiming the 1 kata 10 lakhs of land in respect of which we have been residing since the days of my parents, that we are the tenant in respect of the land, they are the exclusive owner. So although they are claiming, they are admitted that it is belongs to their predecessor, Kamini Mohanto. So that suit was decided. We have filed a written statement counterclaim, claiming that my mother is one of the legal heirs of Kamini Mohanto, and she is entitled to get his share, number 1. And number 2, during his lifetime, that Kamini Mohanto gave this portion of the land, allowed me to construct the Assam type houses and structures. I was residing over that place in a scheduled suit property. Now, besides that, and we made a counterclaim that Kamini Mohanto had other properties. That is, properties described in Schedule X, Y, and Z in the counterclaim, that this to be partitioned. So my counterclaim is regarding declaration of right title interest, partition, and preliminary decree of partition, and for injunction, and for recovery of possession, because the other shares which I have to get, my mother is to get. Now, what happened in the counterclaim in the Schedule Y, there is other 2 plots of land that is also ancestral property. That is not included in the counterclaim. So subsequently filed an application under Order 6, Rule 17, that this property, ancestral property, to be incorporated in the counterclaim because I filed a suit for partition. If it is not included, then my counterclaim will be defective because I have not included all the paternal property, all the ancestral property, not paternal, only ancestral property. So on that ground, we filed an petition under Order 6, Rule 17 to incorporate those share of land which left for partition. So accordingly, the
High Court has allowed the petition.
Lordship.
And they are agreed by
They are agreed by that. So their claim is that I am not entitled to get because my father, the father is died in so and so years. My mother died so and so years. So that is why this succession.
No, that has to be decided.
Decided in the suit, Your Lordship.
Yeah.
Not to be decided by the Honorable Court. That is to be decided. It is, I am not entitled, then my counterclaim will gone. So that portion amended, I have been allowed to incorporate that Y1 and Y2. These are part of Schedule Y. So that is this portion. Whether my submission to learned trial could not commit any illegalities in allowing us to amend the contract. Whether this suit is pending, that will be decided. Their plea will be considered by the learned trial court.
My lord,
That is the
judgment on AIR 2019, RAS 42, civil writ petition number 1286/16. In this judgment, it is clearly stated that petitioner has the order that if the subsequent.
No, forget about that judgment.
Judgment.
You tell me how the impugn order suffers from any illegality.
Yes, my lord. Because
Requiring interference of
my
this-
lord, as per Hindu Succession Act, it is the amendment of 2025, my lord. And their father Kamini
No,
Mahota
no,
explained.
you raise that issue before the trial court. Trial court
That is the another thing, matlab,
will,
but
after
I
taking
have,
evidence,
I have,
decide the issue.
but I have filed this suit, my lord, only for one kotha 10 lesa. Subsequently, they had added another schedule, my lord. So if they have filed another schedule, so they have filed a fresh suit, my lord, separate suit, my lord. That is not along with this
No,
suit, my lord.
no.
File separate
That
suit, my lord.
that is not the spirit of the CPC.
no.
Not the spirit. Sorry,
And their mother is not.
petition dismissed. Some dismissed.
Thank you.
Maybe because of it is a
1 o'clock, my lord, that might be
after
the.
some time.
Yes, my lord, after lunch.
Any other method ready?
Item 11.
May I please, Lordship? Lordship, this is an appeal under section 54 of Land Acquisition Act 1894 against the judgment and order dated, Your Lordship, 20/12/2024. Passed in Miss LA case number 153/2005, whereby the learned additional district judge Dibrugarh dismissed the reference proceedings made under section 18 of the Land Acquisition Act 1894, arising in LA case number DRA 2020-1991. So this is a statutory appeal.
Okay, let notice go at this instance.
Lordship?
Mr. Bhattacharya, you are for respondent number 1.
Yeah.
Yes, I am for respondent number 1.
Whether notice was served upon
My
respondent.
lord, BSNL has not appeared, my lord, that is.
Not appeared before that.
They are not appearing now, my lord.
What?
And they have not appeared in the lower court in the initial stage. That is why this problem has started, my lord. This, first they did not appear. And then they came to the High Court and then set aside that order. And then again that order, that reference case was cancelled by the, after it was
This court.
remanded.
This
Yes,
court.
yes. By the, by the reference court.
Originally, the district judge has enhanced the compensation award. That award was challenged by the respondent number 2, who has not appeared, participate in the initial proceedings. And this honorable court remand back the to.
Okay. Let notice go at this instance.
Yes.
Heard, Mr.
Yes, sir.
Chaudhary, learned counsel for the appellant, and Mr. Bhattacharya for respondent number 1. This appeal under section 54 of the Land Acquisition Act 1894 is directed against the judgment and decree dated 20/12/2024, passed in Miss LA case number 153 of 2005 by the learned additional district judge Dibrugarh. Dibrugarh. It is to be noted here that by the impugn judgment and decree dated so and so the learned additional districts as Dibrugarh has dismissed the LA case number DRA 2020, no, 22/1991.
Well, this is the reference.
Reference case,
Reference proceeding,
Yes,
reference proceedings.
yes.
which is
Dismiss
arising.
the
out of-
reference proceeding, being LA number so and so. By upholding the award of the collector of Dibrugarh. Where is the memo of appeal and the grounds mentioned therein? Admit. Issue notice to the respondent. Returnable in 4 weeks. However, no formal notice is required to be issued to the respondent number 1 since Mr. Bhattacharya entered appearance and received notice. However, extra requisite copy of the petition be furnished to him during the course of the day. Step upon respondent number 2 be taken by reciprocal process. Registered process with AD and also by legal process within a week from respect of respondent number 1, extra requisite copy of the memo of appeal be furnished to Mr. Bhattacharya during the course of the day. Call for the record from the learned trial court. Now, from the court of learned additional district judge Dibrugarh. This is the matter after 4 weeks.
Deeply obliged.
Timing item 10. Lord, this is an appeal against the order passed by the district court, my lord. The reference petition was allowed under the LA Act, my lord, section 18. An order was passed, my lord. That order is under challenge, my lord. My lord, page 36 is the impugn order. Passed in LA reference case number 5 of 2014.
Page number
36, my lord. My lord, this LA reference 5 of 2014 was arising out of a LA case, my lord, 9 of 2005. Certain award was passed, my lord. So the landowners have preferred an application under section 18 of the Land Acquisition Act 1894, claiming a higher amount of compensation.
So, Mr. Gupta, you see, while order dated 24/6/2025, you have been asked to obtain instruction in respect of the calculation sheet given by the court. What is your instruction?
My lord, may I please, my lord? My lord, it so happened that on the last order, the honorable court asked me whether calculation has been made. That function I have shared it to Mr. Gupta, learned friend, and
yes.
And at that point of time, my lord, the honorable court has said there is a system regarding apportionment of payment received. Just like bank, we pay in bank, suppose we have some due, it has to go to first interest, then to principal. So it has been, that proposition has been given by Gurpreet Singh versus Union of India in October 2006, my lord. So that calculation, honorable court has told me to make again. So my lord, I want to file that calculation. I have done this calculation. That calculation, I want to file it through an affidavit, my lord.
Okay. My lord, before that, my lord, one submission I have. My lord, in addition to the grounds which I have raised, one of the main grounds is that the reference which was filed, my lord, that was barred by limitation. That is the basic ground, my lord, which I have challenged. Because the question of calculation would come, my lord, after the court is satisfied that the reference was filed within the period of limitation. If my lord takes section 18 of the Land Acquisition Act, my lord, section 8.
Section
18, my lord. It says, my lord, any person interested who has not accepted the award may by written application to the collector require that the matter be referred by the collector for determination of the court, whether his objection to the measurement of the land, the amount of compensation, the person to whom it is payable, or the apportionment of compensation among the interested person. Subclause 2 says, my lord, the application shall state the grounds on which objection to the award is taken, provided that every such application shall be made if the person making it was present or was represented before the collector at the time when he made his award within 6 weeks from the date of the collector's award. In other cases, within 6 weeks of the receipt of the notice from the collector under section 12, subsection 2, or within 6 months from the date of the collector's award, whichever period shall expire. This aspect was totally ignored by the reference court. My lord, in this case,
you have raised that issue before the reference court?
No, no, my lord.
my lord, that issue,
No.
but it
Objection.
But it's a question of law, my lord, because this reference petition, if my lord will see page 25, it was filed in the year 2014. Page 25. Although the petition number, my lord, can see on the left-hand side in the top left, my lord, petition number is dated 2012, but the reference case was registered in 2014. And in the instant case, my lord, the award was passed in the year 2008. That is, my lord, and the authorities, the SSB authorities, if my lord, I may peruse the payment regarding the land acquisition compensation, that payments were also, my lord, paid to them long back in the year 2000 itself. And it is not in respect of only petitioner's land, my lord. Actually, the entire area is, my lord, 97 acres of land which are acquired. Now, the respondents before your lordship is only one portion in respect of 1 katas of land, my lord, they have approached the court filing a reference. But the area in question is 97 acres. So therefore, my lord, my humble submission is that, my lord, that the reference itself was barred by limitation, and since the landowners have already received their compensation, my lord, in the year 2008 itself, entire amount was paid to the deputy commissioner, my lord, an amount of 17 crores 30 lakhs 126, and subsequently an amount of 99 lakhs 89,242. So, my lord, in my humble submission, the entire reference was barred by limitation. And my lord, therefore, this issue, since it's a question of law, my lord, it needs to be examined. My lord, in support of my contention, my lord, I am relying on 2 judgments.
Mr. Gupta, if we do not finally hear the matter today, let us adjourn it, and Mr. Goswami will file his additional affidavit.
My lord can admit it also because it's a question of law.
Yes, my lord, it can be admitted. LCR may be called for, my lord. This is purely because there are catena of decisions that it is from the date of knowledge of the landowner that I also have at this point of time also, my lord. Even this High Court has also, this Honorable High Court has also passed order recently. Now, my lord, Now, if LCR comes, it would be easier for me also to.
Okay then,
Hmm.
okay. But Mr. Gupta, learned counsel for the appellant, and Mr. Goswami for the respondent. This appeal under section 54 of the Land Acquisition Act 1954 is directed against the Land Acquisition Act is of 1954, is it correct?
1894, madam.
I'm sorry, my lord. By mistake.
1890. Is directed against the judgment and order dated 29/4/2024 passed by the learned district judge Kamrup M. Guwahati in LA, which indicate reference case number 5 of 2014, which in bracket in LA case number 9 of 2005. Why?
My lord, can be arising,
numbers are
my lord, it can be arising out of. Because LA case is, my lord, the original award passed by the deputy collector. That is
okay.
LA
Arising
case.
out of LA case number 9
No.
of 2005. Okay. Where is the memo of appeal and the grounds mentioned therein? And also where is the interim judgment and order dated 29/4/2025 passed by the learned district judge Kamrup M. Guwahati. Admit issue notice to the respondent. Returnable in 4 weeks. Anybody from collector? No. Whether you have served
No, yes, my names are shown, my lord, in the cross list.
returnable in 4 weeks. However, no formal notice is required to be issued to the respondent number, Mr. Goswami.
5 only. madam.
Respondent number 5. No, you are for respondent number.
I have already received.
1 to 4.
No, you are
1 to 4.
1 to 4. Since they are represented by their English counsel, however, extra requisite copy of the memo of appeal will be furnished to Mr. Goswami during the course of the day. Step upon respondent number 5 be taken by registered post with AD and also by the process within a week from today. Rest shall call for the record from the learned from the court of learned district and district judge Kamrup M. Guwahati. Place the matter after 4 weeks.
My lord, my liberty may be given for filing that affidavit.
That can be filed. Because we are challenging them.
Mr. Goswami submits that person to order of this court, he has made a calculation as per
My lord.
dated, order dated.
Last-
When you have been asked to,
It was the last order, madam. 24/6/2025.
to recalculate the compensation amount.
Yes, madam.
Compensation amount, and you will calculate the same and bring on record by filing an additional affidavit. That is accordingly allowed. This is a matter of 4 weeks.
Comment.
Item 12.
My lord, my name is not there. I on behalf of Mr. S.Z. bin Aklas, my lord. S.Z. bin Aklas, my lord, on behalf of him, advocate.
Your
Name
Lord
not
Mama is not here.
my.
Cannot appear.
My lord, S.Z. bin Aklas authorized me, my lord.
So your good name, please.
M. Hussein.
Learned counsel appearing on behalf of Mr.
S.Z. bin Aklas.
Praise for listing the matter after a week.
This is not a regular first appeal. But there is a decree of dismissal of a money suit by the learned civil judge Boy Petamalo. The fact is that the defendant respondent took an amount of rupees 30 lakhs from the plaintiff appellant by executing a hand note on condition that a plot of land will be purchased in his name at Guwahati. In case he purchased the land, the amount will be refunded. But amount was not refunded or suit was filed. All the issues were decided in favor but dismissed on the point of limitation, my lord. Only there is just a 5 days delays or 9 days delays in filing the appeal under section 24 of the Limitation Act. So it was dismissed. My lord, your lordship kindly see the issue number 3 and 4 has been issue number 2 and 3, whether the suit is barred by limitation. Issue number 2, page my lord 21. And issue number 3, whether the suit is not maintained in the present form. Both these issues are decided together. Lastly, it was held there. But page 23, the suit on 25/6/2021. Thus, apparently, the plaintiff has filed the suit after expiry of the period of 3 years prescribed by Article 24 of the Limitation Act. Accordingly, it is held that the suit is barred by law of limitation. But the decision, both the issues are decided affirmatively in favor of the plaintiff, my lord. Issue of limitation issue was decided in favor of the plaintiff, but the suit was dismissed, my lord. That is interesting. And lastly, last para, my lord, page 28, para 23, additional issue whether the plaintiff is entitled to the relief as provided. In view of the decisions on the issues, yes, it is clear that the defendant has taken rupees 30 lakhs, 30 lakhs from the plaintiff and thereafter did not return. This is hell, my lord. He took the money. However, in view of the decisions on the issue number 2, it is held that plaintiff is not entitled to relief, my lord. So the contradictory findings. And there is a 9 days delay, but there is a Supreme Court decision that during the COVID period, the limitation can be extended up to 1 year. I have
Whether
got
you
that,
have produced that judgment before the trial court?
my lord.
Whether you have produced that decision of the Supreme Court before the trial court?
Notice.
Trial court decision. Supreme Court order to trial court decision.
No, that was not filed here, my lord.
Then
The advocate conducting the case. No, it is the first appeal. Your lordship can admit it and the notice may be issued, record may be called for.
heard
At the
Mr.
time
Jason,
of hearing will show.
learned counsel for the appellant. This appeal under order 41, rule 1, read section 96 of the Code of Civil Procedure. Is prepared by the appellant challenging the judgment and decree dated 29/4/2025, first petal on civil case and portata in manuscript number 2 of 2025. It is to be noted here that by the judgment and decree that the learned court below has dismissed the suit of the plaintiff. Where is the memo of appeal and the grounds mentioned there? Also, where is the appeal judgment and decree dated so? Admit, issue notice to the respondents, returnable inquiries that be taken by registered post with AD and also by usual process within a week from today. Rest shall call for the record of the learned court below. Place the matter for its.
Item number 14.
Late legal lordship. Lordship may go to the earlier last order, my lord. Service is complete. And basically the challenge is made here against the order dated 26/9/23, passed in Miss Appeal number 76/2021 by setting aside the eviction orders. The service is complete, the other side is not there. Otherwise, my lord, similar arising out of the same dark, my lord, some matters are disposed of, my lord. Lordship, kindly present this order. Because the learned court below, my lord, they did not consider whether the land in question is whether it is a railway land or not. all these matters are remanded back to the appellate tribunal.
So what is the ground?
My lord, all these lands are belong to railway land, my lord, and they are illegally occupying this land since many years. But illegally occupying the railway land cannot, they cannot claim their ownership, my lord. So these aspects were not considered by the lower court below. So in all these cases, my lord, they are all remanded back to the appellate court, my lord. These cases and this, they are all belong to the same dock. And now they are renumbered as different dock numbers. Even record says that land belong to railway. I have annexed it, my lord. Sita for surveyed villages. These aspects were not considered in.
And you have taken as many as 8 grounds.
My lord.
So which is the ground you have harping on? Ground number?
Ground number 3 and 5. Three, 4, and 5.
We will pass similar.
My lord, duly present.
Number 34.
May please, your lordship. So, see, this appellant was supposed to file an application under order 41 rule 27. We reduce some evidence during appeal stage also. But the insurance company has not been received to the documents that which are supposed to be reduced. So some time may be going to so that we can file this application along with those documents also.
Okay, on the appearing matter, Mr. Kolika, learned counsel for the appellant, the matter is then adjourned to be listed after 1 week.
Can be 2 weeks. It will,
2 weeks.
Yes, 2 weeks. Yes. Oblige it.
Or fair hearing, item 15.
May please, your lordship. Your regular bail application, lordship. Earlier rejected by your lordship, the second time before lordship. Offense lordship under section 21C and 29 of the NDPS Act, trial is going on lordship. Earlier lordship has rejected on merit, and now we have raised that non-furnishing ground of arrest lordship. And the petitioners are behind the for last week.
Record was received.
Yes.
Record has been received.
Received. Yes, Mr. Borthakur, you have gone through the records?
Not,
Ground can.
lordship grounds, detailed record, my lord, I have not gone through, my lord.
You have not gone through.
Yes.
Mention.
No, you have to go through only 3 documents.
Yes,
One
yes,
is the notice,
Yes.
Yes, ma'am.
and the other one is the memo of arrest,
Yes.
and the other one is the inspection memo.
Yes, yes, ma'am. Regarding that aspect, my lord, from the petition also, my lord, those, lordship, kindly after some time, my lord.
After some time.
Number 41, voting CPC, item 16.
May I please, your lordship? My lord, this is the regular second appeal, my lord. The substantial questions of law, my lord, at page 10. Your lordship will find.
Lordship, before coming to the library for short accommodation for today, Lordship. An alarm is, due to illness, he could not come before his honorable court today, Lordship. I pray for some time, Lordship.
No, my lord, the problem is that, my lord, the execution case has been started and tomorrow is the date fixed for, my lord, submission of report. My lord, I am told that they are all set to demolish my dwelling house, my lord, for execution of the decree.
Towards the
unless,
date
my
fixed
lord,
for
the-
order, Lordship,
the
already here
execution
petition has
case-
been heard. In the execution proceedings, petition has
Let-
been heard and tomorrow is the date fixed for order, 17th.
No, my lord,
No,
because there is
17th is the date fixed for order.
17 is the date fixed for order, my lord, and report, my lord, because I am told that
No,
it has been
whether
partially
writ was
decreed.
issued.
My lord, read
Whether
was
writ
issued,
was issued.
yes, read was issued, my lord, and partly, my lord, executed. And thereafter this, because of this, my lord, this pendency of this appeal, my lord, the things has been not done, my lord, execution is not got.
We
My lord, your lordship kindly admit the appeal, my lord,
Lordship.
call
let
for
it
the
be
records, my
sometime,
lord,
Lordship.
stay
Because
the
NLM is
proceeding, my
not-
lord, then, my lord, any date, as my learned friend
We
my
have
lord,
already
says, my lord,
requested.
because
my
from,
learned-
from long pending, my lord, this is, the case is pending since long, my lord. And my
Lordship, we have
dwelling
already
house,
arguments
my
has
lord,
partly
is
heard,
going to
Lordship.
be evicted.
In the
my
last
lord.
occasions, arguments has been
My lord,
partly
your,
heard.
your lordship kindly see, my lord, it is a case, my lord, for partition of ancestral property. The plaintiff is my brother. He filed a suit for partition of the suit property, my lord. Now the trial court, my lord, as per judgment and
Partition of the
decree, my
suit
lord,
property-
trial court
Prima
said,
facie partition of the suit
My
property
lord,
regarding which
state-
I have already buyed from the institute.
no, that part, my lord, I'll satisfy. My lord, the trial court said, my lord, that all the co-owners of the suit patta or the co-pattadars of the suit patta are not made party. Therefore, the suit is bad for non-gender of necessary
Let
party.
it be
Suit
heard
is
along with
missed.
it. Let it be
Number
heard.
one, let me complete.
Number one, my lord. Number two, learned trial court has said, my lord, that the plaintiff has failed to prove the title of his father. My lord, the title of his father is not been proved. Now, substantial question, your lordship kindly see, my lord. I have, my lord, stated at page 10, your lordship will find. My lord, in a suit for partition, first of all, my lord, a preliminary decree has to be passed for ascertaining the share and possession of the not only the plaintiff, my lord, and all as well as all the co-partakers. This is the law. Order 18, order 20, rule 18, my lord, sub clause 2. Now, may I read the substantial questions of law, my lord, whether in the instant title suit number 1.
Mr. Sen.
My lord, I was defendant in the suit. Suit was dismissed by the trial court. Appellate court set aside the judgment passed by the trial court, holding that, my lord, which is absolutely erroneous. My lord, under order 20, rule 18, section 54, section 101 of the Assam and Land and Revenue Regulation Act.
No, let Mr. Alam remain present. When he will be available?
Lordship, 2 weeks time will be granted because he's due to illness, he could not come. Otherwise, we are regularly appearing for this.
No, not 2 weeks.
My lord, my dwelling house is at stake, my lord.
Lordship.
They may demolish at any point of time, my lord.
Lordship.
And
yes,
they are
we will
in hurry, my lord. I am told.
sometime, any date.
My lord,
Any date, sometime.
Day after tomorrow, my lord.
Day after tomorrow, how, Lordship, he is in the medical observation, Lordship. If it is possible, we are already appearing in this. And Mr.
My lord,
Alchemy-
in a second
This
appeal, your
council is
lordship
always
knows, my lord,
appearing.
the law is settled. In a
okay.
second appeal,
Engaged counsel
he
is
is nothing
always
to
appearing.
say. It is the, my lord, the appellant who is to satisfy the court
Honorable court will decide the merits of
my
the
lord,
case.
whether there is a substantial question involved in the case. If it is there, my lord, lordship will formulate the substantial question of law, and then only, your honor, your
That's
lordship
right,
will hear.
but since they have appeared,
My lord, that is
we are
there, my
appearing
lord.
and we have-
But I am saying, I am
part of
stating
the
the
argument
position
is
of law, my
forward.
lord.
Mr. Sen,
My lord.
since they have appeared, one opportunity has to be given to them to
I have-
argue their case.
I have no objection to that, my lord.
Yes.
But my problem is that, my lord, tomorrow the decree will be executed. If the decree is executed, my lord, then this appeal will become
Due
infructuous.
process of law will be followed, Lordship. At the same time, we are.
Due courses of law, my lord,
Lordship,
I
at the same time,
am in second
let us
appeal. I am saying that there are substantial question of
whether
law.
it is,
The first appellate court has
whether-
erroneously passed the
Whether
decree.
is apparent on the error on the apparent on the face of the record, it will come to the merit of the case, Lordship.
My
It will
lord,
come.
error on the
Some
face
time will
of
be granted
record,
because
it is, my lord, he is saying
legitimately we are
error in
seeking
the
for
face
some
of
time,
record
Lordship.
is comes only in review, my lord,
Okay,
not in second appeal.
let it be on Saturday. This Saturday is working day. Let it be. Let Mr. Alam remain present. For
Lordship, next week, Lordship, difficult for us. Again, I may came for.
No,
Then, my lord, your lordship,
Take
and
one second.
next
Because
week, my
Saturday
lord, but
will be-
in the meantime, status quo may kindly be maintained, my lord. in
Then it will be
respect of
same,
this.
Lordship, because tomorrow is the execution proceedings, and at the same time, Saturday will be the same course. So, Lordship, can be a next week, Lordship, we need it. We are
Madam-
requesting only that because we are always appearing in this matter.
That is
And,
true, my lord, but
also, we are put for a
but
part of our
only
arguments,
thing
Lordship.
the lordship will satisfy, my lord, I have
Genuine
satisfied
ground,
whether there is substantial question of law
not
involved.
genuine ground, I'm
Mr.
praying.
Sen, why on earlier occasion the matter was not admitted? It was listed on several times.
Several times.
My lord, it was not taken
was-
up by
it
my lord
was-
justice, my lord. Sometime it was not taken
It
up
was
because of
already heard,
paucity of
Lordship.
time. Because of paucity of time, it was
No,
not
Lordship.
taken up. Thereafter,
No
it was
offense will
listed.
happen.
Court said whether you are taking willing to take up. Then court said
Then-
after vacation. We said after
Lordship,
vacation.
before
after
that,
vacation.
before that, I'm saying the true fact. Before that, the matter has been heard at length from both sides. Also, it has been decided on the somehow to a great
No,
extent.
it was not. It was not
heard
heard
on
in
merits,
length,
Lordship.
my lord. It was.
And-
It was initially we have started our case.
We do not have
but
issue
court
in
said
regard with this.
will
Okay,
not.
Mr. Sen, let it be on Monday. And in the meantime, you don't pursue your execution proceeding till Monday.
Yes, my lord. That may kindly be, my lord, recorded because
No, no.
otherwise, my lord, your lordship, if they execute the decree, my lord, then Monday it will become infructuous.
No,
Your
no.
lordship kindly
Appeal is yet
consider
to be
me.
admitted, so such kind of observation cannot be made.
Lordship.
True, my lord, but considering the my lord urgency of the
No, no,
case,
no.
tomorrow is the date fixed for my lord execution case.
There is always, as why on last occasion, it was given an opportunity, whether it was a good case or bad case.
So agreed by learned advocates of both sides, Restitution is the matter on Monday. You inform the
Lordship, I will
not
definitely,
to
I will,
do the execution proceeding till Monday.
Lordship.
Turning under.
Much obliged.
Yes, madam, I have gone through the records, madam, from the section 50 and arrest memo. It reflects that, yes, at that point of time, my lord, grounds of arrest was not there. But in this case is somewhat different. I'd just like to point out, my lord, trial court's order, my lord, at Annexure 10, my lord. Some of the,
We have approached the learned trial court before approaching this honorable court, raising that ground of lordship arrest. That has been declined.
Page number?
Page 55.
page 55.
Yes.
From third line, your lordship. Paragraph number 3, my lord. During this period, since the arrest of the said accused on 1/12/22, numerous bail applications have been filed before this court, wherein all such petitions have been rejected on merit by holding that in the facts and circumstances of the case, it would not have been possible to complete the trial upon allowing the accused to remain on bail. Conspicuously, in all the bail applications, the allegations as regards violations of provisions of section 50 and 50A of CRPC had never been challenged. The necessity of communication, so my lord, all are these, my lord.
It was rejected mainly on the ground that the earlier the plea was not taken. But that cannot be a,
Earlier, that decisions were not.
yes, lordship, but that
yes.
cannot be a ground now to reject the bail application on.
But on the basis of a, my lord, detailed order, the trial court has, my lord, considering all these aspects regarding, my lord, grounds under section, trial court has rejected.
No, Mr. Portakur.
Yes, my lord.
We are not testing the legality of
Yes,
the
lordship.
order.
Yes.
Yes, exactly.
Our question is plain, my question is plain, whether ground of arrest was.
Yes, my lord, that is
communicated
not
at
there in the
relevant point
record.
of time or not.
It is not there.
It is not there.
Not there. Okay. What is the earlier impugned order?
Earlier impugned order, lordship, earlier rejection, lordship will find it.
Earlier rejection.
Page number 37. This is for the petitioner number 1, 2, and 3. And lordship, then page number 40. Page number 40.
So this is the third application.
This is the second application. 3 of the petitioner number 1, 2, and 3 preferred jointly earlier. And petitioner number 4, along with the one other co-accused, have preferred earlier. And lordship was pleased to grant the other co-accused the privilege of bail.
Heard Mr. N. Hassan, learned counsel for the accused persons, and also heard Mr. P. Portakur, learned additional PP for the state respondent. This application under section 483 of the BNSS 2023 is prepared by co-accused, namely Salma Begum, Donmaya Setri, Umari Setri, and Tulen Hazurika, who are languishing in jail as of since 1/12/2024 in connection with NDPS case number 18 within bracket P/2023 under section 21C/29 of the NDPS Act for grant of bail. Mr. Hassan, learned counsel for the accused person, submits that this is the second bail application prepared by the accused person on the ground that while effecting arrest of the accused persons, the investigating officer has not communicated the ground of arrest of the accused person. In support of this submission, Mr. Hassan has referred to page number.
Lordship, the arrest memo.
Yes.
Page number 46 onwards. Arrest memo, lordship, 46, 47, 48, 49.
Has referred to in the notice.
And notice, lordship, 50, 51, 52,
Has referred
53.
to Annexure 7. series at page number 46, 47, and 48 and
49.
49.
For the 4 accused persons.
And the notice under section 50 CRPC
50 to 53.
as annexer 8 series at page number 50, 51, 52, and 53.
And 50A, Lordship, 54.
And also the notice
It was issued to Lordship one accused. It was not issued to
under section 50A CRPC
page 54.
being annexer number 9 at page number 54. Page number 54. And since the ground of arrest has not been communicated to the accused persons at the time of arrest, the same has violated the mandate of Article 22(1) of the Constitution of India and also the decision of the Honorable Supreme Court in the case of Bobby Procedural and also in the case of Bihan Kumar. And therefore, Mr. Hassan submits that the accused persons may be released on bail. Per contra, Mr. Vortakur, learned additional PP, has clearly submits that going through the exhibits, going to the annexers from page number 46 to 53, it cannot be said that the IO has communicated the ground of arrest to the accused persons. However, Mr. Vortakur has referred to a decision of decision of the learned trial court dated 3/6/2025 at annexer number with the application as annexer 10 at page number 55 submits that the learned trial court of the trial court giving detailed reason has dismissed the petition referred by the accused persons on the ground of non-communication of the ground of arrest to the accused persons. And as such, Mr. Vortakur has opposed the petition. But having heard the submission of learned counsel for both the parties, I have carefully gone to the petition and the documents on the record and also perused the annexer page number 46 to 53, 55. 55. Annexed with the petition. Annexed with the petition. And this court is and having perused the same, this court is unable to derive satisfaction that the IO, while effecting arrest of the accused persons, had communicated the ground of arrest to them. And as such, the right guaranteed to the accused persons under section 22(1), under article 22(1) of the Constitution of India, and also the mandate of the Honorable Supreme Court in the case of Bobby Procedural and Bihan Kumar is violated, and as such, the accused are entitled to bail. Accordingly, it is provided that on furnishing a bond of rupees 50,000 each with one surety of like amount to the satisfaction of the learned trial court, all the accused persons shall be released on bail. The learned trial court will also entitled to impose any condition so as to ensure attendance of the accused person during the course of trial. In terms of this BA disposal.
Deeply obliged.
Number 17.
Right, Vijay, actually. This is a regular appeal against the judgment and decree. Dated 24th in 2024, which is at page
47, and the substantial question is at page 5. The basic ground that I have taken at page serial number 2 and 2, 3, and 5 at page 5 was such: the present respondent as plaintiff filed the suit against us for a declaration of right title interest and recovery of position.
So there is concurrent finding of that.
Yes, that's
what's
true.
below.
But my submission before also is that I have also filed an application under order 41 rule 27 before the learned appellate court below, which I have also annexed at page serial number at annexure 5, page 84. So far, one document is concerned which contradicts the statement of the plaintiff's version, which gives rise to filing of the suit. The plaintiff, that is the original respondents, have taken the plea that on a particular day, we have dispossessed the plaintiffs and accordingly that compelled them to file the suit. That is the cause of action as they have stated. But so far that particular document is concerned, that has contradicts the statement of the respondents as regard to the arising out of any cause of action. Because of the fact that documents particularly reflects our position prior to the sale deed was executed. That means before their allegation is there, we were in possession over the suit land. Accordingly, the question of disposition comes only when a person was in possession. But since they were not in possession, the question of disposition doesn't come. That means no cause of action arose at the relevant time to file the suit itself. But that particular document has not been considered at all, basically on the ground by the learned appellate court below that. So far possession part is concerned, we failed to prove. We failed to prove the khatiyans which was issued. I have stated in our fall, but so far our possession part is concerned, there is no such dispute or contradictory statement amongst the witnesses, and our possession could not be demolished by the respondents. So, considering all these aspects, my substantial question, which is at page 5, serial number 2, reduce 3 and 5. The findings of the learned courts below as regards to the possession, basically as regards to their compelling circumstances filing the suit, is to the department.
No, you tell me, when did you file this petition number 1146 of 2023?
But that was for during the pendency of the appeal.
Pendency of the.
Yes, I am authorized under order 41 rule 27 to file that. Because we have obtained that particular copy through RTI application. As and when we have received that particular document, we have filed along with this petition before the learned appellate court below.
No, that petition was dismissed.
That petition was dismissed because it was dismissed along with the appeal.
And that dismissal order is not the subject matter of this second appeal.
Yes, madam.
Right?
No, madam. So far the appellate judgment and decree is concerned, that application has been rejected along with my appeal.
No, that petition was rejected when?
Along with the appeal.
Along with the appeal.
Yes,
Now, when did you file the petition?
My lordship made 15 July 2023. Madam, the law is such that if
No, whether that petition was disposed of by a separate order or by the impugned judgment, then
by the impugned judgment and decree. Lordship, I am pointing it out. Page, my lord. Apple. The appellate judgment and decree starts from 47. And page 60 is the relevant portion. 60, paragraph number 22. It would be pertinent to mention herein that the appellants had filed petition number so and so dated 15/7/23, filed under order 41 rule 27 CPC, prayed for allowing them to adduce additional evidence, and the aforesaid petition was finally heard along with this appeal, and the said petition is rejected by the order passed today is separate. So far that order is concerned, my lord, my that application was also rejected. Page, my lord, 90 is the relevant portion of the order on my petition filed under order 41 rule 27.
No, that petition was rejected by a separate order.
Yes, page 90, 90. 90 is the order.
So, this impugned judgment is against the, no, this.
Very same day, my
second
lord.
appeal is against the impugned judgment.
Very same day, my lord, when the appeal was heard, on the same day, my lord, my death petition also was heard, and on the very same day when the judgment and decree was passed, my disposition was also rejected by the same order, same day, my lord, on 2014
Can we examine the correctness of that order in this second appeal?
But so far, I am, my lord, to the.
No, you have suggested the second substantial question of law on that point.
Yes. I am also saying to my lord. When a petition under order 41 rule 27 is filed in the appeal, my lord, that has to be heard along with the appeal. This is the law, my lord, clear. And when that particular petition has been rejected, it may be by a separate order, it along with the original order decree, my lord, appellate decree. But the reason for rejection, what has been essayed, and why the reason for submission and filing that particular application, which, my lord, prejudice the appellants. So for bringing on record the evidence which are vital in nature.
Where is that order?
So for, my lord,
that petition?
Petition, my lord, is at, my lord, page 84, annexure 5. And the order passed on that petition is at page 90. And it has been reflected in page 60, paragraph 22 of appellate judgment and decree.
But the question is whether this order, on the basis of this order, you can suggest a substantial question of law in second appeal.
Yes, my lord. When, my lord, that particular petition which involves the fact as regards to possession and disposition, which is the root of filing of the suit, which is at page, my lord, approximately take note of page 9. Page, sorry, my lord, page 9. Basically, paragraph 15, page 11. Paragraph 15, page 11. That is the part of the plaint, my lord. Six schedules are there, or 5 schedules are there. The contention of the response is such that from the said 5 numbers of schedules, the respondents have been dispossessed by the appellants as well as other defendants on 25/4/2014. That means the plaintiffs were dispossessed as per their statement on with effect from 25/4/2014, and whereas the document which we have sought to be proved and obtained through RTA application reflects that our position was prior to that and they were never been disposed at all. That means the reason and the circumstances which compel the plaintiffs to bring on the suit fails. Apparently, other than that ground, disposition, they have not taken any other ground seeking their right, title, and interest, and for our eviction. That is why this vital document.
Let it be on Monday
My lord,
for further hearing.
my lord,
In the meantime, I will go through this.
that's true. As,
Pardon, Mr.
pardon, madam, my lord.
Learned to product petitioner. Appellant.
Appellant.
Less than Monday for further consideration.
All right.
Lordship, we are the plaintiff's appellants. This is a case of concurrent finding. Our
Your
case was
suit
that
dismissed.
both the suit was dismissed, appeal
By
was
both the court below.
both the court below. My problem is that in my evidence on affidavit, I have written that I have exhibited these three documents, exhibit 1 to 3.
1 to 3.
1 to 3 to prove my title. But in the judgment, it was reflected that no such documents were proved. No such documents were there exhibited. Therefore, at the time of delivering the judgment, learned trial court should have made an report.
Show me the relevant paragraph in the judgment.
Judgment. 2948.
So Bhagavati,
Yes.
After some time or on another date?
Other time.
Another date. Okay. Heard Mr. Bhagavati, learned counsel for the appellant, and Mr.
P. Sharma.
P. Sharma, learned counsel for the this one. Heard in part, list the matter on Monday. But come prepared.
Lordship.
Item 20 and 44.
Wait, please, sir. And this is regarding substitution of respondent number 16. My lord, there are 6 IAs before your lordship, my lord. My lord, the IA number 1086, 1089, and 1088 are, one is substitution, one is condonation, and one is abatement. My lord, there is some mistake appeared in the name of the heirs of the respondent number 16. So, my lord, I have made other 3 IA for correction of name of the heirs of the respondent number 16.
No, first come to IA number 2186.
2186 is correction of father name of the legal heir in IA number 1086.
Yes, Mr. Ghosh. You are the opposite party here.
My lord, here
Any objection?
No, I have no objection because at my instance, my lord, early hearing date has been fixed.
I have no.
Then thereafter, after fixing the date of hearing, they have come up with a substitution petition, that too against the person whose proceeding was ex parte all along from trial court. Here also, after service of notice, he expired. Now we come up with substitution. All the petition may be allowed, my lord, but my case may be heard early.
I have no
as per
objection.
our
I have no
order.
objection, my lord, regarding here.
Because there is an order, my lord, of your lordship, my lord, fixing the case for hearing. It has already been ordered as been passed.
Within 10 days, my lord, I shall serve doctrine notice on this legal error, my lord, because this legal error is necessary.
Now coming to this question of notice, my lord. All along ex parte, my lord, against the person, this substitution has been filed.
Okay. Heard Mr. KKT, learned counsel for the applicant, and Mr. Ghosh, learned counsel for the opposite party. This application under this application is.
My lord, he is one of the
Mr.
one.
Hawk for respondent number?
One.
Then Mr. Ghosh for?
I am for respondent number. Respondent number 2, 3, 5, 6, 12, 17, 18, 19, 20, 21.
This application is prepared by the applicant for correction of the father's name of the opposite party number 1. Let Hidoksuti Chakraborty. Deleting the name is Hirendra Chakraborty in the cause title of IS serial number 1086 of 2025, arising out of RSA number 249 of 2007. Which is the correct name?
Correct name is Hirokjyoti Chakraborty.
Hirokjyoti Chakraborty. But inadvertently it was mentioned as Hirendra Chakraborty.
My lord.
Hirendra Chakraborty is the father of Hirok.
Mr. Dale, learned counsel for the applicant, submits that in the IS civil number 1086 of 2025, the name of the father's name of the opposite party number 1 was mentioned as, was written as Hirendra Chakraborty instead of let Hirokjyoti Chakraborty. Then as such, there is a requirement for correcting the aforementioned name in the IS civil number 1086 of 2025 by mentioning the same as that Hirokjyoti Chakraborty. Hirokjyoti Chakraborty. Mr. Ghosh and Mr. Hawk submits that they have no objection. We are taking note of the submission of learned counsel for both the parties and also considering the facts and circumstances of the record. This interlocutory applications that's allowed. The father's name of the opposite party number 1 in the IS civil number 1086 of 2025 shall be corrected as late Hirokjyoti Chakraborty. Mr. Day shall furnish shall submit the amended cause title of the IA number 1086 of 2025 within 1 week from today. Then the others IA, can we dispose of today?
It's same order, madam.
Same order.
Same order.
No, it can dispose of today, my lord,
All the
by allowing the substitution. Only substitution of respondent number 16. 16, my lord.
Okay, Art Mr. KKT, learned counsel for the applicant. And Mr. Ghosh for the respondent number also, opposite party number also. And Mr. Cock for the opposite party number 1. This interlocutory application under order 22 rule 4 of the Code of Civil Procedure is referred that the applicant for substitution of the legal heirs of the respondent number 16 RSN number 209 of the code. Mr. T. and learned counsel for the applicant submission. Respondent number 16 in RSN number 249 of 2017 suffered demise on
On
that?
2012, 2021.
On 2012-2021. Leaving behind one Imani Chakraborty as legal heir. And as such, there is a requirement for implementing the said legal heir in place of the respondent number
16.
16. Mr. Hawk and Mr. Ghosh submits that they have no objection. Taking note of the submission of learned counsel for both the parties, this interlocutory application is allowed. The name, the legal heirs of the respondent number 16 is substituted in RSN number 249 of 2017. In terms of this IA instance disposal.
No, not RSA, my lord.
IA.
IA only.
Accordingly, we'll pass order in
My-
other IA.
And in the main case, my lord.
Main case.
Part Mr. KKD, learned counsel for the appellant. That Mr. Bok, who respondent number 1, and Mr. Ghosh, who respondent number 6. List the matter on suggested.
বলো তুমি শুনি তুমি।
My lord, next week, my lord.
Next week, no,
Next
this notice has to be served.
After 15 August, second part.
My lord, second week of August, my lord. In the
Second-
meantime, my lord, I shall serve those notice only. Within 10 days, I shall serve those notice.
22nd August.
My lord, it may be long because my amount is lying with the government, my lord, because of one stay order taken in the writ petition, my money has not been disbursing. Though
No, that is stay order we cannot deal with in this RSS.
that is why by bringing that order, my lord, this honorable court fixed the case for hearing. I have brought the notice of this honorable court in IA, my lord.
On 12th of
12 August.
Once.
21.
Legal. My lord, in this case, my lord, service is completed, my lord. As per last clause, in court's order, my lord.
Mr. Day, you are here?
Not here, in earlier case, but notice has to go, my lord. There's only condonation petition.
Condonation petition. What no? I
21, 25.
Document corrected whether this convolution petition, substitution petition, and a notice, now notice is to go.
In this condemnation application,
My lord.
earlier notice was not issued.
No, no, not. It was issued, but it returned back due to this mistake in the name. Father's name. It was not accepted by the legal area.
Heard Mr. KK, learned counsel for the applicant. Issue notice to the opposite party, returnable in when?
Hello, within 10 days, madam.
Returnable. 12 August. Step be taken by registered post of PD and also by usual process within 2 working days from today.
Apply.
Yes,
Yes, my lord. Here, my lord, husband filed one application praying for restitution of conjugal right. In the court of my lord lordship, his petition is page 19 and excerpt 2, my lord. And wife is, my lord, praying for transfer this case, my lord. Before the family court, seal, my lord.
whether notice was issued.
Notice is completed, my lord, as
When?
Lazima court's order. Perhaps, my lord, he is not interested, my lord.
When the laws in the court passed the order.
25. Complete. Date to Korean. 21/5/2025.
Heard Mr. A.M. Barbuya, learned counsel for the petitioner. None appears for the respondent on call. So, though the order of the laws in my court dated 21/5/2025 indicates that service deemed to have been completed upon the respondent. Place the matter on next Wednesday. 23rd. In the meantime, the Restitution put up a note indicating as to whether any counsel entered appearance by filing new Kalapnama or not.
Well, earlier interim order may be continued.
Interim order passed.
23. Obliged.
May I please, your lordship? Your lordship, as per office note dated 29/4/25, your lordship, notice was served to respondent number 2, your lordship, and they denied to accept the notice, your lordship. And upon respondent number 3 to 7, your lordship, notice has been served. They are the pro forma defendant. Office note dated 29/4/25.
So notice deemed to have been
Deemed to be served, your lordship, as they
how many respondents are there?
respondent 6, your lordship. Respondent number defendant number 1 is there, and
You have
2
both
to
respondent
6.
number- Respondent number 1.
1.
Heard Mr. Paul, learned counsel for the applicant, and also heard Miss
R. Begum.
R. Begum, learned counsel for the opposite party number 1.
1. On behalf of YS Manoj.
Appearing on behalf of Mr. Y.S. Mannan, learned conducting counsel. Mr. Paul, referring to office note dated 29/4/2025, submits that Respondent number 21222324 refused to accept notice. Then as such, notice deemed to have been served upon the aforementioned respondents.
And your lordship, as per office note dated 7/2/25, notice was served upon respondent number 3, 4, 5, and 6.
Mr. Pal further submits that as per office note dated 7/2/25, notice upon respondent number 3, 4, 5, 6 have already been served, but no one entered appearance on their behalf. So list the matter for this IA has to be disposed of first.
Yes, your lordship.
This IA is for what purpose?
Substitution, your lordship.
This
Setting
is
aside of
limitation-
amendment.
Limitation.
Limitation
No, this is
857.
under section 5 of the Limitation Act.
Yes, your lordship.
You have filed any objection here?
No, lordship. I have no any objection.
List the matter on next Wednesday for further consideration.
Oblige, your lordship.
24.
Was a transfer petition, the petitioner wife is seeking the transfer of the divorce that has been filed by the husband from Guwahati Family Court 2 to Nagaon, my lords.
Lordship,
Objection has been filed by them.
Lordship, in this case, the conducting counsel, Mr. D.S. Singh, he made a request for VC, Lordship. He is in New Delhi. So there is some network connectivity issue. I am told that network is very low. He is coming back today, Lordship. Can it be tomorrow or day after tomorrow, Lordship? Because the before the family court, it is fixed on 19. So there may be some urgency on the part of the petitioner, Lordship. Tomorrow or day after tomorrow, Lordship.
Okay, part is that
J. Singh, my lord.
learned counsel for the petitioner.
Petitioner wife.
Mr. D does learned counsel appearing on behalf of Mr.
D.S. Singh.
D. Singh.
D.S. Singh. My name is also there, Lordship, but he is the conducting counsel.
Learned counsel for the respondent submits that conducting counsel Mr.
D.S. Singh, Lordship.
D.S. Singh, who will personally appear before this court on day after tomorrow. Day
Lordship, Lordship.
Yeah.
As for the convenience of the Lordship.
And accordingly, the matter is then adjourned to be listed on Friday
Lordship, on admission column, Lordship. It is.
in the admission column.
I'm obliged.
25.
I have 143, my lord.
Yes.
I filed this petition for
Any objection, Mr. Das?
There is a delay of 448 days, madam. In respect to that, madam, I filed written objection also. Madam.
And that's all right. You have filed your written objection, but what is your objection?
Objection is that, madam, though they have said that they did not, the particular petitioner, madam, did not have any information as to whether the present, the one of the other defendants had taken steps for filing appeal or not, because her case is that she had deputed one of the defendants to take steps for filing of appeal. Now she has not mentioned in the application, my lord, as to on when she had authorized that particular defendant to take steps. And another issue is that, my lord, they have said that only on 10/11/2024 they came to know about these particular proceedings that is pending. But in that regard, my lord, there is a notice on in a execution case, my lord, which, my lord, on 18/8/2023, that notice has been served upon all the particular defendants, my lord, in that case, my lord. So, my lord, perhaps, my lord, that we have annexed in a written objection also, my lord. So it cannot be said that since the date of the impugned judgment, that is 19/6/2023, till the filing of this present RSA, my lord, that is on 13/12/2024, they did not have any information or they did not have any knowledge. That perhaps, my lord, is misleading, my lord.
Yes, Mr. Ahmed.
This is my petition, my lord. I clearly mentioned about the facts that only one in two defendants appeared and contested the suit. Then the suit was a degree. Then, my lord, being a lady, I authorized the defendant number 3 to take a step for filing a appeal. Then, but suddenly, I believe that he filed and take steps for filing appeal. But suddenly, my lord, some official persons come to the land, and then he come to London. Execution case also been filed. Then immediately I approached the respondent number 3. The whether in the file appeal you filed and everything, he then declared that no appeal has been filed. Then I asked him to furnish all the documents, but he refused. Then I
So
came to
this
the court.
matter is part heard before another bench.
It is 14.
Yes, for order of 18/6/2025.
Right, my
Taking into account the matter would require further hearing, list the matter again on 6th and 7th.
on that court number 14, my
Heard Mr. Ahmed, learned counsel for the applicant, and Mr. Das for the respondent. The order dated 18/6/2025 indicates that the matter is heard by another bench of this court. And accordingly, it is provided that Restitution list the matter before appropriate bench.
Honorable Justice Borua, next week, my lord.
Pardon?
Next week, my lord.
Next week. As early as possible.
It
As
is a-
early as practical.
26.
If I may, my lord, the service report has not been received by the, it's not tagged with the record, my lord.
Pardon?
My lord, we had taken steps. My lord, the matter was last fixed on 26/5, my lord. Subsequently, we have taken steps. My lord, however, the process service note has not been tagged with the record. My lord, in the e-courts forum, there have been 4 documents which are shown.
You are appearing for respondent number?
Yes, my lord. I am appearing for respondent number 1, 1 to 5, and 9 and 10, your lordship.
9
But
and 10.
respondent, we have already received the notice yesterday at 5 p.m., your lordship. So we could not file also Ukalatnama. So we will file Ukalatnama.
Okay.
And thereafter we will file our
What
objection.
says the above?
7 and 8.
7 and 8.
The state of Assam.
7 and 8. How many respondents are there?
My lord, 10 respondents.
10.
Yes, ma'am. My lord, service is complete, my lord.
So there remains only 6.
Yes, my lord. I am for 1, 2, 3, 4, and 5, and 9 and 10, your lordship. They're all brothers and sisters.
6. 6.
6. I
My
don't
lord,
know how
for
to
6, my lord, 6 is state of Assam, my lord.
6 is state of Assam.
Mr. Bhattacharyya is for 6 and?
I am for today, I am for 7 and 8, but for today, 6 men, I make an appeal because the standing council is not there, so I will appeal for today. But by the time he will come.
So service completed then?
Yes, yes, ma'am.
Heard Mr.
GMTS, my lord.
Learned counsel for the petitioner and Mr.
Yes, Islam.
S. Islam, learned counsel for the respondent number 1 to 5, and 9, 10, 10.
9 and 10.
And Mr. Bhattacharyya for respondent number 6, 7 and 8. Since service has already been completed and LCR has also been received, the matter may be listed for admission hearing. But a record will be required.
My lord, No, my lord, we have tagged the relevant documents with the.
Okay. Apo- last. Uh, um, since all the parties entered appearance, is the matter after?
My lord, after 2 weeks, my lord, first week of
After
August.
2 weeks.
Your lordship. My lord,
After 2
4
weeks.
weeks. My lord, we have to file our objection also, your lordship. And we are 7 brothers and sisters, all are residing here and there, your lordship.
You were right, online. The learned counsel for the respondent number 1 to 5 and 9 and 10 submits that he may be granted some time to file objection.
Yes,
There is a law, this is the matter after 2 weeks.
My lord, a date may be fixed.
18th August,
Deeply obliged.
27.
Mass obligation.
May it please the lordship, the I is for condonation of delay in filing the readmission of appeal application, your lordship. And the at page 17, lordship. This is, I have annexed the cause list. On 12/3/24, the matter was listed in the cause list. Page 17, item number 8. In that case, our names were not shown in the cause list, lordship. Earlier engaged counsel's names were shown in this cause list. So we missed on
Item
that.
number,
Page 17, item number 8 is the matter. In
RSA 14.
appellant's column, lordship, our name were not shown. So we missed that item in on that day. And it was dismissed for default. That order is at page 20 is the order. Page 21, lordship. So thereafter, lordship, on 16/12/24, the decree holder, lordship, they came to the Switzerland to vacate.
no, when you have been engaged in this case?
Yes, lordship, earlier. Okay, to put aside. Page, para 3, page 6, lordship. When we are given the wakalatnama, because the earlier council, he expired, lordship, senior council. So they gave us the wakalatnama. When we went to file the wakalatnama, then only we come to know that it was already dismissed for default earlier. So after that, we filed a readmission of appeal, and that was allowed by the court. But again, lordship, this name were not shown in the cause list, so again, it was dismissed for default. Para 3, I have stated that earlier part, lordship. And para 6 onwards, lordship. On 16/12/24, the decree holder come to the Switzerland to vacate our Switzerland, lordship. After that, the client inquired about that come to our.
Where is the earlier order dated 15/10/2020?
Lordship, it is in the miscase, lordship, MC. At page 13. Miscase 19/25, lordship, readmission of appeal. Page 13. Operative portion. Order dated 15/10/20.
Yes, any objection?
Yes, my lord, because earlier as well, my lord, by the same, when a matter was dismissed for default on 18/1/2018, by the same set of advocate, they filed a condemnation petition, along with the petition for abatement of my lord, setting aside the abatement and no subsequent substitution of legal heirs of the sole respondents.
Earlier one was not in our period, Lordship. On the demise of the senior counsel, that time itself, it was.
Taking the same ground. Earlier also filed condemnation petition, taking the same ground,
But it is
regarding the demise of learned senior counsel.
impossible if our name is not shown
My
to
lord-
track the matter, Lordship.
My lord, they should have been filed a Ukalatnama separately in the second appeal. Supposing they did not file, they only filed Ukalatnama in the IA, my lord. That's why, my lord. And 2019, it was restored, my lord. Everything was restored. Then last 6 years, they are silent. And again, matter was again dismissed for default. Now, by the same set of advocate, now they file an application saying that again, due to demise of learned senior counsel.
No,
And-
that's all right, but his name was not reflected on that day in the comments.
Yeah, there is because my lord, they did not file separate account number. They should have been filed local separately in the second appeal, which they did not. That's why my lord, they are not shown, my lord. Because only IA they file. IA file, new certificates will come, file an IA with the Ukalatnama. But that after disposing of the my lord IA, they should have been filed separate Ukalatnama in the second appeal, which they did not. Now the execution proceedings on, they says, well, they only came to know regarding business for default on 16/12 when I visited the suit land, my lord. And asked them, my lord,
Even Lordship, on merit also, Lordship. The suit was dismissed by the trial court because, Lordship, there was
No,
a
tell me whether you have filed your Ukalatnama in the RSA.
separately we did not file because we filed in the readmission application. Our name is shown in the order sheet itself, Lordship.
No, that's all right, but
Advocate for the petitioner names are shown, Lordship. Normally that is done, Lordship, because it is a continuation process, Lordship. After readmission,
okay, any other objection?
the way, my lord, that today we have filed application. No, so in IA, my lord, we have filed Ukalatnama on the respondent. Our names on only IA, not appeal. Today it's a calculated cause list. If lordship allows today, then we have to file Ukalatnama separately in the second appeal.
No, that's all right. Do you have any other objection in allowing this application?
Well, look, execution proceeding is on. As already initiated, only because of that regarding their.
No, that execution proceeding cannot be a bar in readmitting
Yes,
this
ma'am.
appeal.
Now, my lord, the way the case is projected in the that is not believable, man. The way the pleadings has been made for restoration.
they have not
Maybe.
filed written objection, Lordship.
If you allow, my lord, I will file, my lord. Sometime maybe given my 2 weeks time, I will file a written objection, my lord, being all this really on record.
But Lordship, it can be a hard, Lordship, because thing is that, Lordship, issue is very simple, Lordship. We filed this suit against the.
No, Mr. Ahmed, you say they have filed their Ukalatnama in the IA.
IA, my lord.
IA is part of the RSA.
Are, my lord.
So is there any requirement to file a separate Ukalatnama in the RSA?
Yes, my lord. They will not be shown in the RSA, my lord. Today itself. Yes, they have to file. Today itself, I can see our cause list. Today we have filed, we are appearing on behalf of the respondents. Our name only shown on the.
No, that's all right. Is there any requirement in the rule that they have to file separate Ukalatnama in the RSA also?
But my lord, actually, it is necessary to file, my lord, separate Ukalatnama, my lord.
No, whether the rule requires it.
That is not.
Our High Court rules is concerned, I have to go through the same High Court rules regarding filing. My lord, and some other, can see the pleadings made in the condemnation petition, my lord. They come to know on 16/12/2024. When he came to know, when visited to Suitland, asked them to vacate the land because the High Court has to dismiss the petition for default. Then only they came to know. Last 6 years, they were silent. They were kept numb last 6 years.
Okay, you file your objection.
That's my lord. 2 weeks time maybe given.
Heard Mr. Data learned counsel for the applicant and Mr. FKR Ahmed, learned counsel for the respondent number.
All respondents.
All the respondents. Mr. Ahmed submits that he has filed his Ukalatnama today, When you have filed Ukalanama?
No, I have not filed yet. I will file, my lord.
He will be filing his
2 weeks time may
Ukalanama
be given, my lord.
during today?
No, 2 weeks time may be given. No, I have not yet filed, my lord.
Okay, that he has an instruction to appear before this court. And he will be filing his Ukalanama and objection
Yes, my lord.
within 2 weeks from today. List the matter after 2 weeks.
Lordship, a date may be fixed because execution case is there. Earlier, there is a status quo order in the miss case, Lordship. Since it is dismissed for default, that is also gone. A date may be fixed.
Mr. Deca, you were also responsible for that.
But, Lordship,
You slept over six years.
no, Lordship, our name is not shown. That is why we do not.
Maybe, but what you have inquired about the fate of the case.
That was,
For
that,
6 years he will remain silent.
no, Lordship.
Anyway, let him
Yes.
file objection. We'll check.
35 and 36.
May I please, Your Honor. In this case, I have filed an MSc appeal. And in that,
You are for
my lord, I am for appellant in fact.
this, who filed this IA?
My lord? Yes, I have filed the appeal. Against that, they have filed a cross objection along with, my lord, delay petition.
No, today this IA is,
I is listed, my lord.
they are absent today.
Yes, my lord.
None appears for the applicant on call, Bhagwan, Mr. Sahu, learned counsel for the present. Respondent opposite party present. List the matter after 1 week. In the event of subsequent non-representation of the applicant, appropriate orders will follow.
Obliged.
I am for the respondent, my lord. I have to file an objection, my lord. I have already drafted the same. 1 week time may kindly be given.
May please your lordships. My lord, office note dated 15/7/2025 lordships in Mat appeal lordships. LCR not received lordships.
So we will issue reminder then.
Lordships, my humble prayer lordships, the daughter is staying with me lordships. I do not have any source of income. Lordships, may I pray a direction may be issued because already I have a prayer to pay the maintenance of rupees 25,000 per month. Lordships, it is very difficult to maintain myself and my daughter. Daughter is staying with me, lordships. A direction may please be given to pay at least that maintenance amount, lordships.
Lordship, I am going to file objection, my lord, in this matter. I am, my lord. And my lord, furthermore, my lord, the petitioner has not approached.
So you pay the maintenance amount.
Lordship,
Already there is an order.
no order is there, my lord. for
No
maintenance.
order.
No, my lord. And my lord, my
Order
lord-
is not there, lordship. There is a prayer in before this honorable court, lordships. ISC 1441.
Lordship, that petition appellant has not even filed any application before the learned court below for maintenance, my lord.
Lordships, it was,
Here, in this case, my lord.
lordships, it
Let,
was.
let him file objection, we will see. Heard Mr. R. Sharma, learned counsel for the appellant, and Mr.
M.S. Taluk.
M.S. Talukdar, learned counsel for the respondent. Mr. Talukdar submits that he may be granted 2 weeks' time to file objection. So, is there any provision for filing objection in appeal?
My lord, yes, well, I have some record to bring in this case, my lord. That's what- My lord, the
Because on the
appellant has
basis
executed
of, on the basis of
income, my lord.
record, and hearing, we have to decide the appeal.
My lordship-
Lordship, objection on
May-
IA, lordships.
May I please, your lordship?
No,
Lordship,
today, this,
for maintenance, my lord, asset,
I-
liability and income.
transmitting the record without further delay. Transmitting the record without further delay. List after 2 weeks. In IA, you take down, heard Mr. So-and-so. Mr. Talukdar submits that he may be granted 2 weeks' time to file objection. This is in IA number 1441. Here is accordingly allowed, recessal is the matter after 2 weeks.
Lord,
Yes.
2 weeks.
Yes.
Lordship, may I pray, a date may please be fixed, Lordships.
Okay.
4 August. Lordships, and also Lordships, on the next date fixed, Lordships, this interim payment of maintenance may please be considered, Lordships.
Let him file objection. We will definitely consider it.
38.
Interim period of the petitioner will be considered on next day.
38.
Material also. Lord, we had initially, my lord, filed a writ petition, my lord, challenging the order passed by a land graving tribunal, my lord. Thereafter, my lord, that writ proceeding, my lord, was converted to a civil revision petition, my lord. Now, if your lordship will see the last order, my lord, we were directed to furnish the certified copy of the impugned order, my lord. That we have, my lord, filed by way of an additional affidavit, my lord. And also, my lord, we were directed to file fresh memo of appeal, my lord. That also we have furnished, my lord. Now, the only thing which remains is that, my lord, the LCR of that land grabbing case, my lord, has to be called for, my lord, for final decision only in this case, my lord.
Yes, any objection?
My lordship.
LCR was not called for.
No, my lord, because it was initially a writ proceeding, my lord.
Heard Mr. S. Das, learned counsel for the petitioner, and Mr.
K. Talukdar.
K.
K. Talukdar.
K. Talukdar, learned counsel for the respondent.
1, 2, 4, and 5.
1, 2, 4, and 5. And service in respect of other respondent completed.
Yes, completed.
It is submitted at the bar that the LCR has not been called for, though this no, and the same will be required for proper adjudication of the dispute in this revision petition. Accordingly, it is provided that all for the record from the Court of Learned.
Land grabbing case number 15 of 15, my lord, from the Court of Additional District Judge Kamrup, Amin government.
Land grabbing case number 12 of
15 of
2015
15,
from the
madam.
Court of Learned Additional District Judge Kamrup, Amin.
But one more prayer, my lord. The thing is that, my lord, in that, my lord, proceeding, my lord, they have already taken steps with regard to the execution, my lord. But till the next returnable date, my lord, can there be any protection, my lord? Because yes, that was
earlier, whether
yes,
you met
because
the fair.
yes, because that was with regard to the writ proceeding, my lord. But subsequently, when this was
Subsequently, this matter was listed before this court.
yes,
But no such prayer was made.
yes, prayer was made, but my lord, the earlier order was not continued, my lord, the interim order. But now, my lord, this is a fresh prayer after, my lord, the writ proceeding was converted to a civil revision petition, my lord. Otherwise, my lord, if the matter is executed, my lord, then it may be infructuous, my lord.
No, unless you made an application,
My
where is the question for consideration?
My lord.
Because this order is very specific.
Yes. Because
there is no interim order, the question of extending the interim order does not arise.
yes, with regard to the, my lord, interim that was granted.
You file an IA.
My lord, my lord. Highly obliged. The date be fixed, my lord. Date.
6th August.
My lord.
39.
May I please? This is my IA for making condonation of delay in preferring the appeal. The delay is of 29 days, my lord.
29, 39 years, 5 years.
No. The original delay from the date of order is 39, but once I filed it in the registry, it was computed that 10 days was minus for the certified copy, and it was given as 29 from the registry, my lord. I have written as 39.
So why you could not file the appeal?
My lord, I've stated my reasons. My lord, may kindly come to, my lord, page 6. Because there was lack of coordination and miscommunication with the council who was conducting in Lakhimpur this case, my lord. It was informed to me about the judgment and the decree. I'm the petition. I'm the wife in that case, my lord, and I am residing in Calcutta. So after the trial,
I was there and I was not aware of the fate of that was a fault on my part. I should have inquired, but I left it on the conducting council, my lord. So he informed me on 18th of November about the judgment and order. Then thereafter, I requested him to give me the certified copy of the order to prepare the appeal. Prepare an
18th of
appeal.
November of which year?
2024, my lord, last year. The order is of 17/9/2024. And he obtained a certified copy from the lower court on which was received on 18th of November 2024, and he informed me that day about that there has been a decree against me, that a divorce has been granted to my husband. So thereafter, my lord, then I called him up.
Yes, madam, what is your objection?
My lord, my objection is that it is correct, my lord, and it's true also, that for condonation, honorable court takes lenient view. But my objection is that and subject to sufficient cause. But the cause shown by my learned friend that he was prevented to approach this honorable court in time because of the misconduct of a counsel who had conducted the case in the trial stage. My lord, the learned counsel against whom the allegation has been made is not before your lordship. Secondly, there is no such statement that they have approached the bar council for commitment of misconduct. More so, at this time, my lord, the online portal is there and the judicial system has provided online portal to know the progress of the case, not only the progress, the result of the litigation also. Now, it does not lie on his mouth that they were unaware that such thing had happened. So, online portal is there. Every day, the order gets lifted up. Then, secondly, my lord, whether your lordship will be pleased to accept the accusation and allegation against a practicing lawyer who had conducted the case all through, and more so when he's not
He
before the
has
court.
submitted that there is
So that will
on
get
his
under-
part also.
That will be injustice, my lord, because they have not said that they have referred the bar council.
No.
And in order
He has
to-
admitted that there is fault on his part also.
And it is unbelievable, my lord, that a lawyer will send the photocopy of the judgment to prefer an appeal. That is something unbelievable. So, my lord, only to cover up the lapses and negligence, they have filed the petition. There is no sufficient cause, only allegation against a practicing lawyer, my lord. And
No, besides that ground, he also admits that there is fault on his part also.
My lord, if I may submit, my lord, there is no allegation of misconduct. Whatever transpired, I've stated in my petition. My lord, I left the fate to the council. I'm not leveling any allegations on the council. When I asked him to give the certified copy, he sent me the photostat copy. Then again, and I asked to send me the certified copy because for filing in the appeal, we need the certified copy. So thereafter, it took almost 2 to 3 months for him to send. That is the only, I'm not leveling any allegations on the conduct or is there any misconduct by the council, my lord. It's just whatever transpired, and I was in Calcutta, my lord. So only thing was that I was having the consultation through telephonic consultation, my lord. That is my submission, my lord. And the delay is inordinate, not inordinate, my lord. It's 29 days, 28 days.
So let us condone it. We admit the appeal. We hear the case on.
because I have made my submission, the online portal is there. It doesn't lie on their mouth that they were unaware.
Sometimes there is also delay in uploading the judgments and order also. In here also, same day we cannot upload it sometimes.
In my humble opinion or submission, that there is no sufficient cause. Maybe allowed with some cost. Maybe allowed with some cost.
No, had it been the case of husband, then the matter would have been different, but he is a lady. Would it be justified in imposing cost? That too, she is residing at Calcutta.
I made my submission, it is up to your lords.
Okay. Heard Mr. Fatiri, learned counsel for the applicant. and Ms. P. Soduri, learned counsel for the respondent. This application under section 5 of the Limitation Act 1953 is preferred by the applicant and read with section 39 within bracket 4 of the Special Marriage Act 1954 for condemnation of delay of 29 days or 8 days.
28 days, my lord, as per the
28 days.
registry.
Then preparing connected matrimonial appeal against the judgment in order dated 17/9/2024 passed by the learned district judge Lakhimpur and Lakhimpur entitled within bracket divorce number 55 of 2019. Mr. Patiri, learned counsel for the petitioner, and my applicant submits that the applicant is a lady and she resides at Calcutta and there is some delay in obtaining the certificate copy.
Certified court.
Certified copy. And certified copy, as the same was furnished to him by the applicant on 18/11/2024, though the judgment was pronounced on 18/9/2024. And that the delay is not intentional, rather it is circumstantial, and he has some arguable point in the appeal to be heard on merit, and therefore it is contented to condemn the same. On the other end, Ms. Soduri, learned counsel for the respondent, vehemently opposed the petition and submits that the delay has not sufficiently been explained. And this application has been filed to harass the respondent, and that in the event of allowing this application, some cost may be imposed. But having heard the submission of learned counsel for both the parties, I have carefully gone to the petition and the documents as on record. In view of the explanation being offered by the learned counsel for the applicant, and also in view of the explanation put forwarded in the appeal, in the application, this court is of the view that the delay of 28 days in preparing the connected appeal has sufficiently been explained, and therefore the delay of 28 days in preparing the appeal stands condemned. In view of the order passed in I number so and so, now the registry will proceed to register the appeal and list the same before the court as practicable. List according.
Item 40.
May I please your lordship? Lordship, in this appeal, on the last occasion, the honorable court was pleased to issue notice on the appeal and also on the stay petition. And we have taken the step together, and a note, and the office note regarding taking of steps has been reflected in the IL lordship, in the stay petition. The appeal, it has been shown that no step has been taken, but we have taken the step. It has been reflected in the IL. In the office note dated 16/6/2025 in IL.
How many respondents are there?
Two, lordship.
You are
Yes,
for?
I'm appearing for the respondent number 1, your lordship. Just we have received the wakalat number today from the Lakhimpur district, your lordship. I'll file the wakalat number by tomorrow, your lordship. Claimant number 1, that is Lakhin Narayan Nath, your lordship.
The claimant.
Claimant.
If respondent number 1 is the claimant. Lordship, in the last order, if lordship pursued the order dated 31 in the IA, the stay was still returnable date. It was to be
Heard, Mr.
Yeah, child.
Learned counsel for the applicant and Mr.
And Millie, your lordship.
And
Millie, lordship.
mainly learned counsel for the
Respondent
number one.
One.
Respondent.
Claimant.
Number one, question bracket, claimant. Mr. Mele submits that he has received wakalatnama today and will be filing shortly. This after 2 weeks awaiting service report upon respondent number 2. Interim order passed earlier shall continue.
41.
I'll get it.
Please, lordship. My lord, respond number 1, A, B, C. As per order of this, my lord, earlier order of this honorable court. We have already taken the step, but respond number 1, A, B, and C appeared. But
All
respond
the
number,
persons are represented. All
Yes.
the respondents are,
no, only respond number 3.
respondent number,
C is the driver of the vehicle. 2 is the owner as well as the claimant. This is the case.
you are representing?
Respond number 1, A, B, and C.
Claimants, all the claimants. But there is a no, my lord, oh,
The notice upon respondent number 3 is not served.
not sir, my lord. As per my lord, office note, so far I have seen. That
Heard
is
Mr. Pal, learned counsel for the applicant. And Mr.
R. Karim.
R,
R. Karim.
Korim.
learned counsel for the respondent number A, B, and C.
1 A, B, and
Respond number 1A.
1A, 1B, 1C,
my lord.
1C. Whether you have taken a step upon respondent number 3.
Yes, we have taken, my lord. In both ways also. But there is a note, my lord, specific, my lord, office note.
After 2 weeks awaiting service report upon respondent number 3.
See, my lord.
Your lordship,
In
Your lordship, there is a small prayer. Inadvertently, while filing the wakalatnama, it has been recorded as respondent number 2, 3, and 4. But it ought to have been right respondent number 1A, 1B, and 1C. So I may be allowed to rectify that, your lordship. In the
The learned counsel is a learned counsel for the respondents. Number R1, A, 1B, 1C is allowed to make necessary correction in the wakalatnama.
Yes, sir. Your lordship.
My lord, my lord, the interim order may continue, my lord, till date.
Interim order.
Yes.
Is there any interim order?
Yes, yes, my lord. In the IA, my lord.
Interim order pass earlier shall continue.
Well, date may be fixed on after 3 weeks like this, man.
When the interim order was passed?
Yeah, past my lord, 28/5/25. Till date, today is there, my lord.
Okay.
My lord, date may be fixed.
No.
Notices.
Let the service complete.
40 to 43.
Much of this. After 2 weeks, my lord. At least after 3 weeks or 2 weeks.
2 weeks.
Much of this.
Please, Lordship, there's a delay of 34 days, my lord, in filing that appeal. We have substantially explained, my lord, I was a chartered accountant student appearing for exam. Thereafter, I sent my son to Hyderabad.
You were a
I was pursuing chartered accountant exam, my lord. That we have already annexed, that certificate we appeared that exam is 13, my lord.
So when the judgment was passed,
It was passed on 29/11/24, my lord.
and when you came to know about the judgment?
No, my lord, judgment, we informed the client subsequently after that order had come up. But he was pursuing his CA exam, so he appeared for a CA exam on 25/1/25. Since he has to study, so he said that once I finish up my exam, I'll come up and whatever required will do. Immediately after the exam, he went to Hyderabad to give his son an admission. So we have annexed all the admission slips, the air tickets, and thereafter, coming from Hyderabad on 29th, on 1st, he had a sister's marriage. My lord, may see page 13.
34 days.
Huh?
34 days delay.
34 days.
Yes.
May I please? Lord, as such, I'm not opposing the delay, but I'd like to make a few submissions. My lord, filing of this appeal is, in my humble submission, my lord, is an afterthought because I have already filed an appeal where the substantial question of law has been framed. That is item number 43. And my lord, it was filed, this appeal has been filed after my appeal, which was admitted, and the Honorable Court, it was filed after withdraw, and also, my lord, an important fact, the pre-deposit, the decretal amount, what was withdrawn by him. And during the pendency of the appeal, of my appeal, then, my lord, can he file an appeal after accepting the decretal amount?
No, in this application, we perhaps cannot
My lord.
consider that as well.
My lord, my lord.
Ah.
As such,
Let
I'm not
it-
opposing
let
the
it,
delay, because he was studying.
Let us condemn this delay.
My lord,
At the time of admission, we will consider your submission.
my lord.
But Mr. Sayola, learned counsel for the applicant, and Mr. Pateri for the respondent, opposite party. This interlocutory application under section 5 of the limitation act 1963 is prepared by the applicant for condemnation of delay of 34 days in filing the appeal. Mr. Sayola, learned counsel for the applicant, submits that. Though the judgment was pronounced on 29/11/2024, against which the connected appeal is being preferred, the applicant could not, the applicant proceeded to,
So he was pursuing his CA exam.
applicant was pursuing CA examination. CA examination,
Which was eventually, he gave his CA exam on 25th January 25.
which ended on 25th January 2025. 2025. And on such count, the applicant could not approach the court in time. And the delay is not intentional, rather it is circumstantial, and under such circumstances, Mr. Sayola contented to condemn the delay. Mr. Pateri, learned counsel for the opposite party, submits that he has no objection in condemning the delay of 34 days in preparing the appeal. Whether taking note of the submission of learned counsel for both the parties, and also in view of the explanations of forthcoming for the delay. And the documents enclosed with the application, this court is inclined to condemn the delay of 34 days in preparing the connected appeal. In view of the order passed in the I, now the rest will proceed to register the appeal and list the same before the court as soon as practical.
Much obliged.